I gotta do, I gotta set it
I'm all right.
Good morning. Good morning. Today is Wednesday, September the 11th, 2019. This is a regular meeting of Commissioners Court of Grimes County, Texas. It is Wednesday, the 11th day of November 2019. The time is 9 a.m. We are located in the Grimes County Annex Building, 114 West Buffington Avenue, Anderson, Texas. At which time we are going to call this meeting to order with our invocation, our Pledge of Allegiance to the U.S. flag, our Pledge of Allegiance to the Texas flag. We're going to ask Charles Tompkins, if he would, to open us this morning with the invocation, and then if he'd remain standing, please, for the pledges to the flag.
Let us also remember that this is the anniversary of a great tragedy, 9/11,
Amen.
and people that are still dying from the results of the toxic that happened. But we also remember that is the day that this United States came together.
Amen.
Father God, we thank you for this opportunity to come together, and we remember those that we lost on 9/11 and those who are still being affected through the sickness and the disease, and all of us who are affected mentally, because that was a great loss. But Father, your word has taught us that in this world, these things will happen. And Father, we bring this commissioner court to you, the judge and the commissioners and all of those, Father, who play a part of this court. We know that you reign on the highest court. For we ask for your wisdom on the lower court, that every issue will be resolved in a timely manner, that everyone, Father, will be pleased with the outcome. And we thank you. In Jesus' name we pray. Amen.
Amen. Thank you, sir. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Honor the Texas flag. I pledge allegiance to the Texas, one state under God, one and indivisible. Would you be seated, please? To be in compliance with legislation that has come out of the 86th state legislature, we do have a sign-up process that if you did want to speak for public comments, just to make a public comment, or if you want to speak to an agenda item, that you would be required to fill in a request for that. The court would like to recognize Mr. Steve Story would like to come and address the court. So Mr. Story, would you identify yourself and what you would like to speak about, sir?
Thank you, Judge. Good morning, Judge, Commissioners. My name is Steve Story. I'm here representing the American Legion, Post 640 here in Anderson. 9/11 is a day we never forget. On September 20th is another day we never forget. It is POW/MI Recognition Day. 82,000 service members never came home. Some are still missing, some are still unaccounted for. In honor of that and in remembrance of that, our post, the American Legion Post, on Friday the 20th at noon will hold a ceremony to recognize and we'll have some conversation, we'll have some speakers talk about, experiences and things like that, but mostly to remember that there are still people unaccounted for, including people right here in Anderson, from Anderson. So you're all welcome. You may see posters around town. Our posters now in the Examiner for the next week. So everybody's invited. We'll have some refreshments at 11:30 a.m. Some posters say p.m. Typo. I'm an old guy. So we'll have some light refreshments at 11:30, and we'll start at 12, and we'll get everybody back to work relatively soon. Thank you.
Thank you very much, sir. Court would like to recognize Janice Trent and Maxine Dry.
I'm Janice Trent, this is Maxine Dry, and we represent the Auxiliary Post 4006 in Arizona. And we want to make you aware of the Suicide Awareness Month in September. It began in 2007. Each day, an estimated 22 veterans commit suicide.
I gave mine away. Can I-
So if y'all would wear the teardrop in honor of them, I would appreciate it. The blue teardrop is the veteran symbol. And you can use it to hold open conversations with someone you know that is having an issue. They desperately need your help. And there's a number on here, and I'm sorry to get emotional, but it's just bad.
Thank you.
Thank you so much. I have to tell you, Janice, the one you gave me, I ran into an individual and I had it on my tie, and he said, "What's that?" And I told him what it was, just, "I'd like to have one of those." So I gave him mine, and I got another one this morning.
Thank y'all very much.
The message is getting out. Thank y'all.
Thank you.
The court would like to recognize Commissioner Barbara Walker. Commissioner,
Good morning.
good morning.
I would ask that the court will consider that although a couple of weeks ago it was determined that we don't have to have court every week, but in light of some of the stacks of papers we've been getting and contracts, I think need to be really looked at, investigated, delved into. There are a lot of issues that we deal with on the agenda that 3 days is just not enough time to get it all in. So I would ask that the court would maybe consider going back to at least a first and a third or every week court.
Okay.
Thank you.
Pay remains the same.
Yes,
Okay.
but the workload is a lot thinner.
The court would like to recognize Mac Vaughn.
Good morning.
Morning.
How is everybody this morning? Janice, I really appreciate that. I got a call when I was in seminary that my dad had put a gun in his mouth and pulled the trigger. So yeah, it's a definite need. Okay.
Yes, sir.
I just wanted to comment on agenda item 8 about the improvements at the Grimes County Fairgrounds, which I think is so desperately needed, and I think it's a good plan. I do have a little caveat that we could add to it. Judge, we talked about it briefly, but there's a great revenue source around the clock out at the fairgrounds that could be taken advantage of since you're upgrading the sewage system and septic system and everything else. There's turnstiles out there that can be expanded that will accommodate RVs, motorhomes, etc. Grimes County, or I'll put Anderson and Navasota, have nothing for anyone. And it needs a lift station. I'm not sure what it is. I have rules and a bunch of other stuff I've collected as I traveled. But there's a revenue source out there that can be capitalized on, not just on special events, but around the clock. Thank you.
Thank you.
Thank you, sir. Ms. Mary, are there any others?
No, sir.
Thank you, ma'am. Thank you for your comments. Moving to consent agenda items number 3. Consider and take action to approve the treasurer's list of claims and bills. Consent agenda item number 4. Consider and take action to approve payroll. Consent agenda item number 5. Consider and take action to approve budget amendments and/or line item transfers. And there are a number of them this morning. So it would be consent agenda items number 3, 4, and 5. Commissioners, do you have any comments, questions, or concerns regarding any of those items?
I'd like to ask Commissioner Dobianski, do you know what year the budget budget amendment number 3, what year is this FEMA reimbursement for? Or
Year 3, I mean,
budget item number 3?
budget item number 3.
Do you know which year, sir?
That's the October 2018 flood.
2018? All right. Well, thank you. If there are no comments or discussion, I'd like to make the motion to approve consent agenda items 3, 4, 5.
That's it. Is there a second?
Second.
There's a motion before the court to approve consent agenda items number 3, 4, and 5 by Commissioner Walker, seconded by Commissioner Dobianski. Is there any further discussion? Hearing none, all in favor say aye. Aye. Opposed? Motion carries. That will bring us to agenda item number 6, American Legion McCloskey Post 640, Adjutant Gary Williamson. It says, consider and take action to proclaim September 20, 2019 as POW MIA Day in Grimes County and authorize the county judge as signatory.
Good morning, I'm Gary Williamson, adjutant for McCluskey Post 640 here at Anderson. As already been announced earlier by Mr. Story that we are having an event on Friday the 20th and I'd like to present a proclamation for the benefit of the court to declare for that date. May I read it, please?
Yes.
Thank you. Proclamation. Whereas the American Legion is committed to achieving a full accounting of all POW MIAs from the Gulf War, Vietnam War, Cold War, Korean War, and World War II. This means returning living POWs the reparation of their remains or finding convincing evidence why neither of these is possible. Whereas the month of September is designated as a remembrance month for POW MIAs and September 20th, 2019 is National POW MIA Recognition Day. And whereas on September 20th, 2019, in honor of National POW MIA Recognition Day, many Americans take the time to remember those who were prisoners of war, POW, and those who were missing in action, MIA, as well as their families. And whereas the members of the American Legion McCluskey Post 640 will hold a short ceremony in remembrance of our nation's prisoners of war and missing in action of all wars, and whereas the Missing Man White Table will be displayed at 415 Hill Street in Anderson, Texas on Friday, September 20th, 2019, and the POW MIA flag will be flown at the address on that day of remembrance. Therefore, I, Joe Fouth III, Judge for the County of Grimes, Texas, do hereby declare the month of September as a remembrance month for POW MIAs and September 20th, 2019 as a National POW MIA Recognition Day. Any questions? I'll get it.
We had a request from the paper to get a picture.
Oh,
Could we get Mr. Story up?
what do you want us
Judge, I think we need to take action. It says take
to
action.
take? You need to take action tonight. You want to do it all together here?
Yeah, just stand right here.
We've got some of our members here present. You haven't taken action yet.
Block out the commissioner.
That's
Well,
good.
we could stand.
Block out everybody.
Let's get
Why don't we
the,
just
let's
stand?
get the commissioners up. There we go.
Get my little chair. There you go.
Right in there, Bill.
Let me stand on it too, Phil.
Welcome to my world, Philip.
Okay, I think I have everybody. Good, y'all did good. 1, 3, 1, 2, 3. Do one more. 1, 2, 3.
Very good. All right, thank you, gentlemen.
I move to proclaim September 20th, 2019 as POW MIA Day in Grimes County and authorize the county, or is it, yeah, authorize county judge as signatory.
Second.
There's a motion before the court on agenda item number 6 by Commissioner Mallett, seconded by Commissioner Walker. Is there any further discussion? Hearing none, all in favor say aye. Aye. Opposed? Motion carries. Proclamation signed. Where's Garrett? There you are, Garrett.
Thank you, sir.
You're more than welcome. Thank you.
You want a copy of it?
Cam.
You want a copy of it?
Gary, will you make sure we get a copy of that, or,
With or without your signature?
well, with the signature,
We got copies.
because we'll need to make it a part of our record.
I've got copies, you can re-sign another one.
I can do that.
Cherie will give it to you later.
Okay, that's fine. Thank you, sir.
Don't want to slow down your operation here.
Operation number 7, agenda item number 7. Thank you for your help. Agenda item number 7, review, discuss, and take action on certificate pay for criminal deputy district clerk. Diane LaFleur, good morning.
Good morning, Diane LaFleur, District Clerk. Okay, as you know, I'm here to request certificate pay for my criminal clerk. Jennifer holds a master's certificate in telecommunications as well as an advanced jailer's license. In the past few weeks, the governor has put into place a new executive law that I will read. Beginning January 1st, 2020, all future grant awards from the office of the governor to counties shall require a commitment that the county will report at least 90% of the convictions within 7 days, which is a biggie, to the Criminal Justice Information System, which is CJIS, at the Department of Public Safety. By January 1st of 2021, you will have 5 business days, which is a bigger biggie. Okay, so with that said, I'd like to say that her master's certificate and her experience will enable her to get that job done as required by the governor now, which is very important for several reasons, which the main reason is so we don't lose our funding. But I was just going to show y'all what a CJIS report is. Just showing this part of it, the arrest and the charge is done by the jail when they come in. Then the DA's office does this part. And then at the very end, it's our job to get this, which gives all the information that shows what they were charged with, so that when that policeman on the street sends out to get a criminal history on that defendant, he gets this. And the governor wants it within 7 days now. Used to, there really wasn't a push. I don't remember now the time frame. But anyway, so I want to add that Jennifer has worked with my office since January 1st of 2017, and she's worked for Grimes County since 2002. Since she's been my criminal clerk, she works closely with her fellow officers. Of course, you know, in law enforcement, forever your fellow officers, no matter where you go. And when we're in a trial setting or in ancillary court, she, with her license that she has, it enables her to assist if there were some sort of breakout or any kind of problem in the courtroom. She's qualified and certified to either pick up and do whatever she needs to do to help the officers. And I think that's a lot. There's not any clerk in the county that can do that. So with all that said, any questions you have, but I would like for y'all to please consider her and give her certificate paid.
And is that the master's?
Mm-hmm.
And the cost of that is $1,800 a year?
Yes, sir.
Does the job that she's performing require that certificate?
Sure, it will, especially now with the new governor's push.
Okay, share with me why going from the time frame that we have now to going to 7 days, it makes it more valuable or more necessary for that individual to have that certificate.
Well, I'll say this, if someone that didn't have that certificate was going to work for me in my criminal department, it would almost be impossible without any experience or certificate to get that job done in 7 days and to get it done correctly. Her knowledge with her certificate, because of the schooling she's had, she knows the codes, she knows the numbers. That's almost priceless to me, because I was the criminal clerk before I became the district clerk, and I know exactly what it entails. And the codes, there's a book about that thick of codes, and you gotta put the right code in. If you have a murderer and you have somebody that's a burglar, well, you gotta have the right code, because whenever that cop, it's all about, you know, safety. And whenever they go do that criminal history and they get, this guy shows he, you know, had possession charge when in fact it was a murder charge, to me that's...
How long did you do the job?
I did it 10 years?
Did you have certificate pay? I mean, did you have this certificate?
Yes, but there was no pay involved.
But you had the master's certificate on it?
I don't have a master's certificate.
Okay.
Judge, the importance of this is that the governor issued the executive orders here within the past week, I believe, and it's in response, or the orders are in response to some of the actions that are being taken across the United States with regard to some gun control measures. And it's important that this information is entered into the system.
Right.
So if somebody has an issue with a gun, that it's brought to law enforcement's attention, in addition to the other issue that Ms. Lepore.
Then it gets in there sooner than later is what you're saying, the information.
Correct.
And by her having met the qualifications of that certificate pay, she's learned the codes, which is gonna allow her to navigate through the process more quickly and efficiently?
Well, the efficiency is the main thing. And also, let me add that whenever someone's been charged and they come back and they are on probation and they come back to revoke that probation for some reason, that's got to get in there too. And with her knowledge that she's learned by getting the certificate, I just think it's very important and very helpful to the county. And at the last meeting, I don't want to quote you, but you stated that anybody with a certificate should get certificate pay.
Anybody that has certificate that the county is going to be using,
Exactly.
utilizing, if it's an asset, I think they should get paid for it.
Right,
But
right, I
just
agree.
because somebody has a certificate and they're qualified to do something, the county's not using that asset, I don't think they necessarily need to be paid. So,
Well, and I'll go on further to the courtroom situation. If you've got a deputy that's guarding an inmate during a trial and they need a break, they've got to call a deputy off the street to come give them a break when she can do that, or she does do that. And that's not in her job description. She loves this county. She wants to do what she can, especially for her fellow officers.
okay.
I want to ask, the report that you turn in, the sieges,
Yes, ma'am.
are you the only department that turns in sieges reports?
No, ma'am. The county court does too.
Okay, so
Our county clerk.
that's Carolyn Newman?
Uh-huh. That would be Vanessa.
So she doesn't have a certificate?
Not that I'm aware of.
She sure needs to get one.
I just wonder what other counties do that don't have somebody on board that has a master's certificate, even though it's been a new law going into effect. It doesn't sound like it has to be part of the job, because what do other counties do that don't have somebody with a certificate? The job still has to be done. I think the state recognized that the job still has to be done. Is she working strictly with criminal?
Mhm.
Does she work strictly with criminal?
Yes, ma'am.
So in her days, that's what she does. She works strictly with criminals, and she has 5 days to enter this information, or 7 days.
7 right now. Mhm.
So I just wondered the necessity of actually having to have a master certificate to do the job. If you've got other departments with sieges, people working on sieges, do they have to be qualified as a master?
Well, I'm speaking for my department.
Yes, ma'am, but I'm just saying, as a whole, we do have other departments that work on that same system, and that's not a requirement to work on the system.
If I can address that a little bit, it might clear some of the issue up based on my prior experience.
And that's working in the probation, not being a criminal.
Yes, we
Okay.
had to complete the same forms. It's a basic requirement to access that system that somebody be trained and, I don't want to say certified, but obtain a certificate. She has an elevated certificate that not only allows her to access that system, but access other systems throughout the criminal justice system as a whole, throughout DPS. It's become very important now that whoever is doing that have the ability to go in there at an advanced level possibly and clear up any errors that we have, enter data that may not be in there prior to now, because it's all attached to potential grant funding in the future. And 7 days, while that sounds like a lot, is not a lot when you're going through the process. She may not get some of the paperwork back within that time frame. So that's another area that she's probably going to have some meetings about that. But it's as far as what other counties do, I mean, I certainly appreciate that question, but in reality, we need to worry about what Grimes County's doing, because this is what our grant funding is what's going to become affected if we don't properly input the information into the system.
And how long had she been working in the siege system? You say you hired her in 2017?
Oh, well, no, she worked in where the jail part has to be done.
Mhm.
She did that over at the jail
No, when she came to your department. She's been there 2
17.
years working in the system.
since 2007. Well, in the district clerk's part, yes.
So for 2 years, just because the law has changed, it didn't take a certificate 2 years ago. 2 years ago, you were
Well,
not
it
looking
takes
for that
training.
certificate, right?
Well, I didn't, no. But 2 years ago, there was no certificate pay offered. And so after the last court, when I realized that there was certificate pay for communications, then I begun to talk to her and ask her,
Is this
Questions
communications
about-
or reporting?
well, it's reporting, but she has a communications license, she has all the same licensing that some others that are getting the certificate pay have, and some of it she has even more that she can teach.
I'm just asking questions for my sake, because I realized that you were sitting here when that statement was said, and I heard the statement that you made, and I just want us to caution on, issue a word of caution, because I think we open a floodgate on certificates, and is it gonna be something now that Carolyn is required to have? Is it something that somebody else is required to have? I don't know. Or is she gonna have to go for training now? Carolyn's gonna have to go for training. So there are other people who work on the same system. That's what all I'm going to. And I don't know if they have to have that or not in order to work on that system. It doesn't sound like it.
To answer that question, they do. And
Well, she's worked 2 years and the certificate was not recognized, and Carolyn didn't have a certificate. I'm just, I don't know about the grandfathering, and somebody said something. Did I hear that? Yep, Mr. Williamson. I don't know about the grandfathered in, but I'm just saying, if she's talking about a new law and it has to be done because of the new law, and you've been doing it 2 years, did the new law state that you had to have a certificate in order to do it?
Well, I understand what you're saying, your question, but I also understand what the district clerk is saying. As the requirements change, as the laws change, then we're gonna have to change how we do our business to maintain compliance. And it might be that the district clerk needs to, if this is your chief, if you will, you're gonna have to change the job description where that is required. And then if you were to lose this person, the next person that you hire is gonna have that qualification, that certificate, because that's now part of the requirements to possess that job.
Well,
And I know sometimes we say degree required or preferred, you know,
Yes.
so some is shall and some is may. So if they shall have the license to have the job or the certification paid, then we're gonna have to have people that are compliant. Or if the laws are changing and the county clerk's chief is gonna need to get the training and get the certification, then we're gonna have to make that arrangement or displace and hire somebody that does.
Does, Mr. County Attorney, are you aware that it says that they must have that license?
I'm not aware of that, no.
Well, the license, I believe, is law enforcement, and the one that, I guess, the previous one that came in, we awarded the certificate pay, they actually require a license, a basic. They don't require the advanced, but that's, but I mean, that's a betterment to the county, I believe, if you go in and get that additional certification with you. I mean, you do require the basic, but you still go and get the advanced. If this one requires a basic and they have the advanced, it'd be the same situation. I don't know if this one requires a basic certification.
You have to have some training and some certification to.
Well, training for that, but is it actually the law, I think we're talking about the certificate pay for law enforcement officers.
That's what we were talking about with the DA's office, that the DA's office, like the sheriff's office, is law enforcement.
And they actually hold the certificate. I think the sheriff's office may be holding her certificate right now. Is that right? Okay.
I'm just keeping in mind that as we move forward with the, I guess, the challenges that we're gonna face in the near future with the 3.5 cap, we have to be mindful.
Sure.
So,
Now, if the job changes and there's additional responsibilities added because of these requirements from the state, you know, that can be, you know, a different job classification, I think.
I just feel like, and I won't beat it to death, but I feel like with her certification and her master's, wherever she brought it from, if she brought it from Leon County, wherever, to me, no matter where she works in this county would be a plus, and especially take away the sieges, go up to the courtroom. If you've got someone that's qualified and willing and certified or licensed, I think it's a license, not a certification, and willing to go above, I just think those two things qualify that, period.
I think that in the future, we're gonna be considering, these type of certificates. They need to have, some proof or backup. Like you read that law to me, but I would personally like to read it myself, you know.
Sure.
I mean, so some support documents that go with it would be nice. And that's anybody, not just you, but anybody before we get in court, so we can see what the statutes say for ourselves, if you're basing it on a statute.
And also, I don't remember, but it seems to me like at the last meeting, somebody said that master's certificate, you can't just run and get it overnight. It takes a long training to get it. It's not just a boom, run and go to a class and come out with a master's certificate.
It's steps.
You're right. I think that should be priceless to this county.
Is there a motion regarding agenda item number 7?
Judge, I'll make a motion to approve certificate pay for the criminal deputy district clerk.
Is there a second? Second request, is there a second? There's no second.
Thank you.
Agenda item number 8, Fairgrounds Administrator Randy Krieger. Consider and take action to approve agreement between Grimes County, Texas and the Grimes County Go Texan Committee regarding purchase of 2 electronic display boards for the Grimes County Fairgrounds. See attachment number 8. I don't see Mr. Krieger here this morning. Commissioner Cox, are you in a position to share his thoughts?
Yes, I can. I hope everybody's aware and has seen the new signage that is posted out next to the sale barn, that the Go Texan Committee paid for that. And one of the things that we were talking about, or that he would like to see, is if, and it was a very expensive sign, they requested some waiver of fees for about 3 weeks.
3 years, it's 3 years.
1 week a year, yes, to host their event as kind of a reimbursement for their contribution of the sign. And I don't see a problem with that at all. They made that contribution, and it's well worth the expense that they contributed, and I would recommend that we sign this agreement.
If I may add to that, the sign cost over $17,000 total. The Go Texan Committee had been paying $5,000 a year to pay off the note that had been put in place to do the refurbishing of the fairgrounds back in 2002 or whenever that happened. And they felt like that the $17,000 would continue to support the fairgrounds by doing that, and they asked for the 3 year. Therefore, I'll make a motion that we approve the agreement with the Grimes County Go Texan Committee and the county.
Second.
There's a motion before the court on agenda item number 8 by Commissioner Dobianski, seconded by Commissioner Cox. Is there further discussion? Hearing none, all in favor say aye. Aye. Opposed? Motion carries. Agenda item number 9, Grimes County Sheriff's Department Chief Deputy Todd Green, discuss and take action to add police cadet to SO1 pay grade. Chief, good morning.
Good morning. This request is as we've changed adding pay grades to the county to level 1 stuff. We ran across a situation where when we send somebody to the police academy, we generally keep them at their same pay grade. Send them to the police academy so they can get paid while they go into the training and stuff when they come back. What we run into is in the previous, we have, sometimes we alternate where we're pulling that position, so that position may be on the jail side and they go to the academy, but sometimes we have the position open on the sheriff's side and we'll transfer that person to the sheriff's side and to occupy that position and fill the positions in the jail to keep them up to staff. So it's kind of fluid. Sometimes we'll have clerks on the sheriff's side that we send, and we've ran into a situation here recently that we have done that, and looking at the new pay grades, there's really not a fitting for that to be able to move those personnel around so we get them to school. So we would just like the police cadet position to be added, so when somebody does get selected and go to the police academy, we keep them at the current pay and move them based on the needs of the department, either on the 454 side or the 451 side. It's not adding any additional personnel, it's not adding any additional raises or any additional budget funds to it. It's just a designated spot to where we stay so they can get transferred to either department side that suits the best needs and our abilities.
I think I understood that. But I'm not 100%
They're
positive.
currently not in the pay grade, right?
Yes, yeah, there's, all our pay grades are like jailers and dispatchers and law enforcement officers, so, and the latest example is, we have a gentleman that's in the academy right now. When he graduates, he's gonna be promoted to a deputy, and so we had an open position an open deputy position, so we went ahead and moved him, because we had a young gentleman, just got out of Marines that wants to come into law enforcement, and we hired him, put him in jail, so we're just moving, shifts around, and we already know this person is gonna go to the sheriff's side of the deputy as soon as he graduates, so, we moved him into this not a qualification title in SO pay to leave him at his current pay and to meet the qualifications to have him on the 451 side.
So this won't affect your bottom line budget?
Now, this will not affect our budget one bit. Like I said, it's not adding positions, it's not increasing anybody's salaries. It's just that we're able to move people and have them in a 451 position to go to the academy or in the jail side and have them go to the academy.
Gives you flexibility.
Yes.
But we're adding the wording police cadet to the pay grade.
Yes.
And that's gonna satisfy your need, but is that a treasury issue or an auditor's issue? Does that satisfy your need if we have that?
Yes.
So we're doing all this for y'all? Okay.
And to save the county money.
Okay.
I move to add police cadet to sheriff's office 1 pay grade.
Second.
There's a motion before the court on agenda item number 9 by Commissioner Mallett, seconded by Commissioner Dobianski. Is there any further discussion? Hearing none, all in favor say aye.
Aye.
Opposed? Motion carries. Connie, would you make sure you get all the details right, so when it comes out in the paper, I'll know for sure what we did there? Okay. Chief, you're also agenda item number 10, that is consider and take action to approve the agreement between Grimes County and Anderson Shiro CISD and Iola ISD to provide and manage the school resource officer program. See attachment number 10. We typically talk about them as SROs. Please, sir.
Yes. This is actually very similar to the one we did last Commissioner's Court, approving the SRO agreement with Navasota ISD. I received the agreements back from Anderson Shiro, Consolidated ISD, and our Independent School District. And both of them have signed the agreement. It's the same agreement, except we just changed the entity's name in the matter as far as the school. These agreements were drafted by the county attorney, so I believe they should pass his guidance.
It's 1 year and this is already in the budget, right?
Yes, yes. This is just to have a formal agreement.
If there's no discussion, then I'd like to make the motion, we approve the agreements between Grimes County and Anderson Shiro CISD and Iola ISD to provide and manage the school resource officer program.
Second.
There's a motion before the court on agenda item number 10 by Commissioner Walker, seconded by Commissioner Mallett. Is there further discussion?
Just could I ask a question?
Yes, sir.
Chief, there's the dates filled in on one of them. It's intended to be September 1, 19 to August 31st, 2020. Those dates aren't filled in on the other one. Is the intention to have the same term for both?
Yes.
Are you looking at the last page?
The last two, pages 5 and 7 have the dates for Iola filled in, but pages 5 and 7 for the other agreement are blank.
Okay,
Paragraph
am I
L.
seeing the same date in both?
Should be.
Okay,
Well, no, you're looking at the date that it was executed.
I see it.
Yeah, yeah.
Mr. Foltz, is your question answered?
It is, Judge, just when you sign it later or after the meeting, be sure you write in the term, which is in paragraph L, August 31st, or September 1, 19 to August 31st, 2020.
Will do.
Thank you.
Is there any further discussion? Hearing none on agenda item number 10, all in favor say aye. Aye. Opposed? Motion carries. Thank you, sir. We'll go to agenda item number 11, Emergency Management Subdivision Coordinator David Lilly. Number 11, discuss and take action regarding Mrs. Whitley's request for a variance from section 232.001 subdivision plat requirements for the Texas Local Government Code to divide her 4-acre parcel of land located on County Road 203 into 2 parcels of 2 acres each. See attachment number 11. Mr. Lilly?
Yes, Judge and Commissioners. This picture that you have before you is just simply a suggested version of what Mrs. Whiteley is looking to do. It's an approximate, it's not a survey, but it gives you some idea of what she's requesting from the court and looking to do with her property. I'm not sure, is Ms. Whiteley here? She said she was going to try and be here today, but I told her she did not have to be here, but apparently she was not able to make it. And basically, the reason that this is coming before you as a variance request is Ms. Whiteley does not meet the exceptions because the size of her property, no matter how she divides it, it's under 5 acres, and the primary exception that would normally apply is if one of the 2 lots would be more than 5 acres. So she requested consideration for a variance. I did explain to her that if the Commissioner's Court did not approve the variance, then she must go back and submit a plat to be able to proceed with dividing her property.
Commissioner Dobianski, this is in your district, isn't it?
Yes, it is.
Any thoughts?
What is the reason that she's wanting to divide this?
She wants to sell off the portion that you see that's marked on the backside of her property to reduce her tax burden.
Does it have access to a road?
No, it does not currently have access.
So is easement going to be granted to the?
She said that she would intend, her plan is to provide a permanent access easement to that lot as a part of that division of land. I'm not sure if she's actually going to have it surveyed out. Some are usually where it's at like a flagpole where they are surveyed out that way and included with the back portion. Other ones it's provided on the deed as a permanent easement so that they have the ability to access the property.
So if it were to be sold and she's adding easement, is that going to be documented or platted somewhere?
Yes, it will be documented on the deed. If the Commissioner's Court does not require her to submit a plat, then it would be documented on the deed as a permanent easement.
Does that meet our requirements?
As far as access, yes, but again, it's kind of a gray area as far as when we look at access being established. She's not actually building a road, but access needs to be provided to that back lot if she sells it so that it's not landlocked.
Well, instead of that easement, could she probably include that access as part of the split?
Property sold.
Yeah, again, I've shared with her both options, and that she is looking at, which way she would go. And again, of course, that would also apply if there was a plat required as to how she would divide that property. But I advised her usually it's better to have an actual portion of the land included with the lot, but it's not required. As long as, the goal is to make sure that whoever owns, if she sells the front lot, whoever owns that lot doesn't prohibit someone who owns the back lot from being able to access their property. A permanent easement would also provide that protection.
Yeah, I think she just.
Are you talking about
Yes,
County Road
Ms. Whiteley?
11203? Yes.
Yes. We're discussing your variance request.
We were asking a question about the easement to the back property. Are you granting easement to
Yes,
that?
there's one that's already there, but it will have to be extended.
Okay. That's a drive that's already there?
Yes, ma'am.
Okay. But it will be deeded with the property
Yes.
you're selling, so? And it will run approximately along this side, Ms.
Yes, ma'am.
So this easement's actually on your property?
Yes,
Okay. That's already going back there?
yes. There's a church there.
That's what that building is?
Yes, ma'am.
I didn't know if it was your home or church.
Yeah, my home's on down the road.
Okay. So the easement only goes a portion back, and you're gonna add to that easement in the deeding of the property?
Yes, ma'am.
Because you'd asked a question earlier.
If it could possibly have the connection to the 203 be added to that property.
If what?
If instead of an easement, could you sell that portion of the property as well?
Like a flagpole.
Like a
Okay,
flagpole?
where the church is?
Yeah, wherever you want to sell
Okay,
that
well,
property up
that would be
top.
an issue because Otis Greenwood is having services in that church, and I don't want to sell the land out from under him. So
So
it's
it's
a long
still,
story.
okay.
Does the church have easement rights?
Yes, ma'am.
Okay.
That's what's going to be extended.
Okay.
So David, once again, why are we asking for the variance?
Ms. Whiteley asked for consideration of a variance because the only other option would be the plat.
And I just want to sell a small portion of land. I remodeled my parents. My mom was Joy Stevenson, for those of you, if you're not familiar. I remodeled the old home, and I just didn't exactly run out of money, but always there's issues. I've got a couple of issues and no money.
Mr. Fultz, do you see any issue with what you've heard?
It's the same circumstances you face in other variances. You have to be prepared to respond to the next request to say why you granted this one, because equal protection requires that you grant the next one that looks like this. And so you just have to ask yourself, what's the reasoning for having your subdivision regulations? And typically it's for roads and drainage. And this, you're gonna face that issue of the person that potentially buys the back lot may very well have at some point a concern about the road or the drainage. You don't know whether they will or they won't. You could say, I'm granting the variance on the condition that the deed indicate that there's a permanent easement and that the county won't be maintaining it. You put whatever language in your variance you want to. If you don't grant the variance, though, you put on the landowner the burden to bring the road to county specification potentially, or grant a road variance. I don't think that's what you want to do here. I think you want some assurity, though, or some assurance, let's say, that the person who buys the lot in the back is aware that the county's not going to be maintaining that road. That's the issue that you face, is down the road, is someone going to come before you and say, how come you didn't protect me from this circumstance where I now have a road, I can't get an ambulance here, I can't get a fire truck here, I can't get a school bus, I can't get a mail truck. You face those all the time. You're trying to avoid that. And the question is, do you grant this variance in light of the fact that you know an easement is being granted? And if you do you put a condition on that, requiring her to put in the deed when she makes the conveyance that the easement is granted, and that the document reflect that the county will not be maintaining the easement? That's the best you can do, in my opinion, to tell the buyer that there shouldn't be an expectation that the county is going to be responsible for their road.
Would creating a plat do that?
I'm sorry?
Would creating a plat do that?
Creating a plat obviously creates expense, and you have to say to yourselves that you're not ever granting a variance solely on the basis of expense. But it's going to create expense to the landowner to show you what the layout looks like, what the division looks like, and also to, in the plat process, there's a requirement that any roads that are created that are laid out for the benefit of the subdivided tracts, they be brought to county specification, unless you grant a road variance and say, I'm not going to require that in this circumstance. So if you required a plat, you could require the road be brought up to county specification. I don't think that's your desire in this case. In fact, this is consistent with why you created the one exception of dividing a tract into two pieces. But because of the model rules require that if you have a subdivision of property that results in the tracts being under 5 acres, that the model rules are supposed to apply. The model rules were impressed by the Texas Water Development Board, or essentially they were done to obtain a grant. I'm just telling you, focus on what's important here, and that is the rules are to avoid deficient roads and drainage. And you receive complaints about that all the time. How is it that you can help avoid that circumstance in the future of the person who buys the lot in the back complaining to you about deficient roads and drainage?
What I also think I heard you say, it could be simply done by requiring that the variance says that easement rights would be given, and there would be no expectation of the county to maintain the roads.
You grant the variance today on that condition, and then she's required to do that potentially. Now, if she doesn't do it, what are you gonna do? You're not gonna chase her down, but I think that's the best that you can do, at least as far as today's concerned, to be consistent with what your intent behind the rules is, but also to try to avoid the circumstance where the buyer of the lot in the back says, I was unaware the county was not gonna maintain this. I was unaware that I'm responsible for it. That may be the best that you can do as far as action today.
If you all are in agreement, I move that we do that and grant the variance with that wording in the stipulation.
I second.
There's a motion before the court on agenda item number 11 by Commissioner Dobianski, seconded by Commissioner Walker. Is there further discussion? Hearing none, all in favor say aye. Aye. Opposed? Motion carries. Agenda item number 12, also Mr. Lilly, discuss and take action regarding Mr. Redmond's request for a variance from section 232.001 subdivision plat requirements of the Texas Local Government Code to divide his 8-acre parcel of land located on Oak Drive into two parcels, one of 4.255 acres and the other of 3.745 acres. See attachment number 12.
Yes, Judge and Commissioners, this is similar to the previous request. The main difference is no access is being established. Both resulting lots would have direct access onto Oak Drive. I also verified that this particular lot or parcel is not in a platted subdivision. It is an unrecognized or it is not formally approved when this portion of this subdivision was actually laid out and divided. So there was no replat required for this.
Can you tell me which piece? I mean, where's the road? I don't.
Oak Drive is on the north side.
On the north?
Yes, and I know on mine is, yeah, you have a black and white copy too. Oak Drive actually terminates at where there's a driveway that goes into the property now, and the way this is proposed to be laid out, there would be an additional portion of that granted to where it would be extended back to the lot on the left at 3.745 acres. So there would not have to be any access established for that lot. It actually, I think Oak Drive actually does terminate at that location.
I didn't raise in my dissertation earlier about the model rules concerned about water and wastewater. So I assume that the plan is to divide this off and sell that tract. Mr. Lilly, do you know what the plan for water and wastewater is?
No, I do not.
Is there public water there? She's here.
There's public water.
Yes, go ahead.
I'm Katie Capiana, I represent Mr. Redmond in the sale of this property. There is Wixon water at that road, so water wouldn't be an issue to tie into the existing water.
And
lines.
wastewater is intended to be a septic?
It is a septic.
Is there already a septic system there?
No, sir, but there's 3.7 acres, so there shouldn't be an issue with space for septic.
Yeah, the minimum acreage that the county allows for an aerobic system is 1.5 acres. So this is over 2 acres more than what we would require. So there should be more than adequate space to be able to set up an acceptable aerobic system.
So where the Oak Drive ends, there's a little space, I guess, before you get to the blue section. Is that going to be extended? I mean, is this a public road or is this a private road?
It's a county road.
It's county
Yes,
road.
ma'am. And so from what the surveyor had said, that the cul-de-sac has to be for the way the cul-de-sac is for the fire department, because it is a county road. So it was surveyed out as a cul-de-sac based on fire access.
Okay, so this is in a subdivision?
It's an old Darrell Hall subdivision.
Unrecorded.
Unrecorded.
Okay. Have you looked at the property?
I have.
Do you have any concerns about
I
that?
really have no objections to this
variance request. Is this, Mr. Mallett, is this up on your end? Your thoughts?
I agree. I don't have any problems with this at all.
You said Darrell Hall, that raises up a red flag,
I
so.
know, I should have looked that in. Sorry.
But thank you for the warning.
But it is a county road.
Is that a motion?
Yes, I move to approve the request for variance for Mr. Redmond's what is it? 8-acre parcel divided into one lot of 4.255 acres and one of 3.745 acres.
Second.
There's a motion before the court on agenda item number 12 by Commissioner Mallett, seconded by Commissioner Dobianski. Is there further discussion? Hearing none, all in favor say aye.
Aye.
Opposed? Motion carries. Thank you, Mr. Oh, wait, we have one more, we got one more for you, sir. Number 13, consider and take action to approve the addition of 10 handheld radios to the Grimes County 700, 800 radio count. 7 of these radios will be distributed to the fire departments and 1 to the county judge.
And one correction, it should actually be 9 distributed to the fire departments and 1 to the judge.
That would utilize the 10.
Yes, ma'am. Yes, sir. Yes, ma'am.
And we did talk about this yesterday. They're not, okay, they didn't list where they were going. We
Well-
talked about where you were thinking about they were
Right.
going.
In fact, Neil Wendeley is here with the city of Todd Mission. I believe you're here, sir, to represent the fire department on this issue. Specifically, this request came from Todd Mission Fire Department. They are actively using the trunking. In fact, pretty much all the fire departments are using it to a certain extent. But in their case, they're also faced with the challenge that VHF, we recognize that the area down there, the VHF is very spotty at best because it's kind of a dead zone, and we're working to try and resolve that issue. But in the meantime, they need to be able to communicate directly with dispatch more effectively, and when their VHF ground communications that they use during the fire response is not effective to talk to dispatch, they need more capability to do that through the trunking. So that was how the fire chief presented it to me. The original request was for 10, but I explained to her that I do need to hold 1 back for the county judge because the judge needs to have the ability to monitor and communicate on this system also, and up to now, he does not have a radio. I also explained to her that if any other departments have similar needs, then we need to try and be more equitable in how we distribute these 9 radios. I did bring this subject up at the chiefs meeting on Wednesday last week and asked all the chiefs to look at what their needs are and just let me know. I have not received any feedback yet from any of the chiefs. I did talk with several privately on the side, and they indicated to me that the number they have right now is sufficient.
There was also a request made to you, if I make no mistake, from the emergency first responders about radios.
If they have, it's not been a recent request, but.
This was when we were first distributing radios.
Okay.
So I do want to keep that in mind, that you do have first responders, I think it's 7 that they may have mentioned to me.
Okay.
Handhelds, because they're usually some of the first on the medical scene. So that's a concern that they also, that's a number we might need to look at, Miss Mary. They're on they're here this morning on the contract. I don't think I see a representative,
Yeah.
but we do have first responders.
And how many do we currently have that are active volunteers? You said 7, is that still a pretty good number?
Yes.
Okay. Yeah, I agree with you that that's something we do need to address. If they do not have that capability, we'll need to also look at providing that capability to the emergency first responders, the volunteer first responders. To my knowledge, the EMS that serve in the county with St. Joseph, I believe they have the capability, but they their primary that they still use is VHF on the sheriff's band.
Well, can I address that? I do remember the conversation a little bit better now. I talked with the new president, which, or director, which is Lee Arnold, and he said that they were willing to purchase their radios, but they did need the help with the subscription. But they were willing to, I think we had a question or concern about the funding for the radios from they were trying to purchase some out of the remaining balance this year, if they had any, for.
Commissioner, who's Lee Arnold associated with?
Lee Arnold is the director of the emergency first responders.
Oh, okay.
It was Rhonda Ritchie.
Right.
Who initially made the request, but now it's Lee Arnold.
Okay.
And it's possible, again, that Mr. Gilbert may have enough remaining in his stock that they wouldn't have to purchase radios. But as you mentioned, the main concern here is whether they're purchased or they're donated radios like the ones we are using now. The cost for the county is having those added to the BVWAC system, that fee that we pay for the radios to be on the system, so.
And I think he's gonna address that later, but be aware that it may come up in this upcoming year, but we don't pay for the radios until the following cycle.
This
So,
would come out of the
but I did want to bring it to
2021
your attention that they did want subscription from the county, and they would try to purchase their radios, but it's a question of funding right now.
And with that in mind, I will reach out to Mr. Arnold, if he can give me his contact number. And discuss that with him too. Again, I've not had any other fire departments come forward and say they need additional radios, but if there is at least a, obviously we can't give them all 7 at this point out of this, the ones that we're getting at this point, but we may be able to distribute some of those to the EMS if they are, we want to make sure they're able to respond with dispatch also, because they are responding to accidents on a regular basis.
And I'm gonna ask this question to Chief Green. We monitor how many are on the system and how many come off the system, right? Because sometimes if they're broken, then we let Mr. What's his name? Gilbert know that we have a radio.
I know for the law enforcement side, I monitor those, and then when they're coming off, I just took one off the system the other day. That was broken.
So I guess I want to say to you then, as the maintainer of the system, that we know when the radios come off, and there may be a slot to where we're not being accountable, or for radios or paying for radios that we're not using, or a radio that's broke.
Right.
So.
In April, we'll do a full new count. We'll go through and do an audit on all the radios, and then we'll submit that to Thomas over at the BVWACs, and then that's what they base the new budget on.
But is it a possibility that as they come off and some of these radios are added, other radios are added?
During the year, our numbers won't.
They won't change? Okay.
It's taken one time at the year, how many radios we're gonna have. That's what the budget's based off of for that year. Now, clearly, it's on a good faith issue. You don't know that you're gonna put 200 radios on a system and wait for the year to start and have those radios.
So these radios we're adding now will go on the upcoming invoice, not this invoice, okay.
Now, if you have a more urgent need, I'm always willing to wait a little bit longer.
No, I consider you need to be able to communicate, Judge. As the emergency management director, in light of how often we get disasters.
I got all of that.
Yeah.
But
Well, looked like he was finna make a motion. Were you finna say something, or you making a motion?
is there a motion on agenda item number 13? I'll say something.
Go ahead. I make the motion to approve the addition of 10 handheld radios to the Grimes County 700-800 radio account. 9 of these radios will be distributed to the fire departments and 1 to the county judge.
Second.
There's a motion before the court on agenda item number 13 by Commissioner Walker, seconded by Commissioner Dobianski. Is there any further discussion? Hearing none, all in favor say aye. Aye. Opposed? Motion carries. Emergency Management Subdivision Coordinator David Lilly and Commissioner Precinct 1 Chad Mallett review and approve the plat for Kinsey subdivision.
Paper copy in front of you, I have the actual plat. In this particular case, the property owner wished to divide their property, cut out 3 tracts from their property and sell these for the purposes of residential development. And they opted to go ahead and just do the plat. And all these have direct access, as you can see on the bottom edge of it. All 3 lots would have direct access onto County Road 127.
County Road 127,
Yes, ma'am.
which is at the south.
It's on the southern edge, yes, ma'am.
Right here.
This one's pretty straightforward, but we normally have like a preliminary plat and then a final plat.
This was
or
a,
this is
what,
just a-
I did not request a preliminary for this because they're not building a subdivision, they're not building
Yeah.
roads or drainage or anything, they're just simply
Okay,
dividing the property.
but I just, since it's simplicity, I guess we can, is it in our subdivision ordinance that it has to go through different?
Our
plat
rules indicate
stages?
there'll be a preliminary plat and to announce to the world that it's gonna happen. If anybody had a concern, you'd have an opportunity to talk to them about a concern, but they're your rules.
Yeah. I mean, this one could have come, I guess, almost as a variance as well. Truthfully.
Is this gonna have public water or is it,
Yes, there's public water in there.
it's public water there? And you put your eyes on the road, drainage adequate. So they're 75 feet wide by, how deep is that?
No, they're 152.
152?
By 529.
Okay. And what is your recommendations, ma'am?
The simplicity of it, I don't have a problem with, but I'm kind of torn between our procedures of preliminary versus if it's in our regulations. I mean, we probably need to go through and maybe change those up a little bit if it's depending on the complexity of the plat or.
It's up to you. The question is, and as far as I know, the court's headed in the direction that the person in the Road and Bridge Department is going to be left, or be the person that's now carrying out these obligations. And so the question becomes, how much discretion do you want to give to that person to decide when to throw it to the court and when not to throw it to the court? The use of the preliminary is not prescribed in the local government code. It was something that was done before I began, and as I understand it, lots of counties do. Our subdivision regs, I think, are patterned off of Washington County, and they provided for the same thing. The purpose of the preliminary is to announce to the world today, hey, this is about to happen in your area. If you're concerned, this is an opportunity for you to come forward to your commissioner or to Road and Bridge or whomever and say, hey, I have concerns about this thing. Wait a second, I think there's an issue here. There are other things, of course, in our regs that apply to plats, and that's also title opinion and various other things that oftentimes are overlooked as well. And so I think there needs to be some real scrutiny about what your regs are, what your rules are, and if you don't want to apply them or you want some discretion to be built in, then your regs need to say that.
Mr. Walker, what?
Get those things after October 1st.
Oh, okay.
Well, you can look at them before October 1st, so they're ready to go October 1st.
So Commissioner Mallon, are you saying you'd like for it to hang for a while?
Well, I think we're gonna address the issues. I think it sounds like,
It's my intention, as I'm taking over Mr. Whitley's duties as subdivision coordinator, to go through our subdivision regulations and bring forward some recommended changes to you.
So, but they're not currently changes, so.
No. So,
yeah, with the simplicity of this one, I mean, this one could have just as well been brought out as a variance too, so.
But he mentioned the issue of maybe title, did I hear you say?
What's that? Well, there are various things when you file a plat. You're supposed to get approval from 911. You're supposed to have a sign off by the county attorney. There are multiple things that apply in our subregs. And this doesn't have the thing that I think is of real significance to you, and that is the road bond calculation, because there's not a road being created. So that's not a priority, or it's not relevant to this thing. There are other things that come with the plat besides that.
Mhm.
There is a lien holder acknowledgement on here.
If there's a no motion, we'll take no action.
Judge, if there's a concern of the commissioner, I would personally ask that you consider approving this as a preliminary and put it back on the agenda for approval as a final. I mean, that's a worst case scenario.
I move to approve the preliminary plat for Kinsey subdivision.
Second.
There's a motion before the court on agenda item number 14 by Commissioner Mallett, seconded by Commissioner Dobianski. Is there further discussion? So my question, is this a preliminary or a final?
Preliminary.
Preliminary, okay. So the record will reflect. Is there further discussion? Hearing none, all in favor say aye. Aye. Opposed? Motion carries. Thank you.
Thank you.
Agenda item number 15, consider and take action to approve transfer of internet service from USF on to BV Cog. See attachment number 15. Mr. Cannon is not here. He's visiting a doctor who wants to put a needle in his eyeball. So I'll speak on his behalf. That this is, through his research and information, this is a transfer that gives us better service at a lesser price, and the contract is before us. And he's been through it, Mr. Foltz has been through it, so I understand.
I have. The thing he was mentioning to me yesterday or the day before was that he was asking that the master agreement be approved, but that the term begin now to make it consistent with the service order. I think the date on the master agreement says July of this year. The significance of it is somewhat lost on me. His request was to keep them consistent. The service order is the same as the master agreement. I said, fine by me, as long as it's going before the court for approval. You certainly have the court approve to change the date of the master agreement.
It's my understanding they're still waiting on the finalization of the install right before we can actually go.
That's correct, and he was able to work with this company. We can somewhat go month to month and change it when it happens. With that, I'll make the motion that on agenda item number 15, that we approve and consider and take action to approve the transfer of internet service from USF on to BV Cog according to the agreement.
And Judge, to make the master agreement and service order have the same term, is that correct?
That is correct.
Second motion.
There's a motion before the court on agenda item number 15 by Joe Falk, County Judge, seconded by Commissioner Dobianski. Is there further discussion? Hearing none, all in favor say aye. Aye. Opposed? Motion carries. Agenda item number 16, Commissioner Precinct 4, Philip Cox. Review and discuss and take action to approve the interlocal agreement for fire protection services between City of Navasota and Grimes County. See attachment number 16. Commissioner?
Yes, this is just to renew the agreement between the county and the City of Navasota for the fire protection services that they've been offering thus far. There is no change in the amount of service that they charge. And I believe Chief Pitkowski is here. If you want to add anything, by all means.
We'll have to answer any questions that you may have.
And this is beginning October 1st to September 30, 2020.
And the amounts are already in our current proposed budget.
Yes, sir. The same.
Which is a sum of 93,241.
If there are no questions, Judge, I'll make a motion.
Yes, sir.
I move that we approve the interlocal agreement for fire protection services between the City of Navasota and Grimes County.
Second.
There's a motion before the court on agenda item number 16 from Commissioner Cox, seconded by Commissioner Walker. Is there further discussion? Hearing none, all in favor say aye. Aye. Opposed? Motion carries. Agenda item number 17, Grimes County Attorney John C. Foltz, consider and take action on the application of all of those people listening. Anthony Paskett, Dale Walkowiak, Sidney Walkowiak, Bobby Moriarty, Laura Paskett, Gary Moriarty, Rodney Floyd, and James W. Klepper Jr. to vacate the following streets and alleys within the town of Rones Prairie, Texas: a portion of Mayfield Alley, a portion of 7th Avenue, a portion of Johnson Street, a portion of Penelope Street, and the 20-foot alleys located within the following blocks: 23, 34, 35, 36, and 37. See attachment number 17. I gladly turn it over to you, Mr. Foltz.
All right, the process when a landowner, a group of landowners wants to make application to vacate one or more roads or portions of roads involves filing an application more than 20 days before the court's supposed to consider it, and also posting notice in the vicinity as well as at the courthouse. That application was made by these landowners, as I understand it, with the assistance of their surveyor, Stephen Wisnowski. We have had contact with Stephen Wisnowski in an attempt to draft a proposed order for the court to sign today. I'm not here to be a proponent or an opponent of this request. This is their request. Corey tells me that Mr. Wisnowski was aware of today's date. I don't know if any of the landowners are here. This matter came to us through Mr. Walker's office, and so he may have additional information. But I would tell you, an application's been filed. We were given information that it was the request is going to be made and ask if there were any concerns. There were issues about how various roads would be split. The transportation code says specifically if a road is vacated, the road to the center of the road is then owned by the abutting landowner. And so that's a state law. That's not something that you all have decided. It's not a policy of yours. And so we had to examine all of these roads and find which landowner was going to absorb the property to the middle of the road if it was abandoned. And then doing that, we had to draft an order that's before you as an attachment indicating who is going to absorb the various, the roads or the property where the road exists if you approve a vacation. I would tell you it's a significant part of Rones Prairie. It's entire southwest side within multiple blocks, 3 or 4 blocks of that's called the center, where the crossing of 90 and 30 is. There's a whole lot of alleys in there that have never been built out. You all may know that around the turn of the century, the railroad came through and laid out plats for various towns and showed multiple multiple city streets and alleys that have never been built out by the county. Because Rones Prairie has never been incorporated, these would still be under your purview, and so you'd have the ability to say, we're going to build a street out over here. This still belongs to the people. If and when it was incorporated, the city would have the opportunity to build those things out. as a general premise, you can't adversely possess property against a governmental entity. So even if people own things that are on these roads, sitting on these streets now, there's been no adverse possession. It's not been taken away from the government. So these alleys and streets still belong to whatever governmental entity is in charge of roads and streets in Roans Prairie. So this is a question for you to decide. Are you going to vacate all of these various areas? And we have drafted an order that contains survey as well as the meets and bounds, I think, showing you all of the areas that are being asked to be vacated. It's entirely up to you whether you approve that. If you have some discomfort about it, you should educate yourself about what areas we're talking about and what the reasoning is. I'll say one last thing about it. That is, if someone were to come to the county and we owned a piece of property in fee simple, for instance, the new site that was purchased from Centerpoint, somebody came and said, we want to buy that location, you have an obligation to do an appraisal and sell it either in an auction or in a sealed bid process to get the taxpayer the most money that you can. There's a different set of rules when a right-of-way is involved. If all you own is an easement, and I say you, if all the county owns is an easement, then you can vacate that easement and then the owners absorb that property to the center of the road. Truth is, they already own to the center of the road. They just have this easement impressed over the top of it. But you may get that question, I don't know if anybody ever has. Keep in mind, we're talking about two different things, but some folks may have a concern that you're giving away, or it appears that you're giving something away. You ought to be convinced that it's the right thing to do, it's the appropriate thing to do for the people of the county to vacate roads. Judge Shiflett had a policy that you never give away anything. I don't know if she started that in her house with her 7 kids or where she started that, but she was not comfortable with saying that the county was going to vacate roads unless a replacement was granted by the landowner who was asking for it. The various administrations since then have not been of that same mindset. And so I think it's up to you all as individuals and as a collective body to decide this is appropriate. But we're talking about a significant amount of streets and alleys in the small town of Roans Prairie that you would change the makeup. And I know that you all are quite aware that that area is a lot of traffic there now. There's a new strip center or store that's going in there at that corner. There's been talk about the new interstate going through there at some point, and nobody knows when that might be. There certainly may have some effect on it. High-speed rail is going right through there if it's to be built. Just a lot of things that are happening there. I suspect this isn't, the landowners are saying it makes our property much more valuable if we have larger consolidated blocks that don't involve streets and alleys. You have to decide as a court, is that what's best for the county? And again, I'm not a proponent, I'm not an opponent. I've not even talked with the landowners in this case. I was given this information, and as is usually the case, we drafted the order to present for you today, and I don't have any other information to give you at this point.
I have a question on page 3 of the order, the third whereas. It says, whereas Texas Transportation Code 251.051B states a unanimous vote of the Commissioners Court is required to close, abandon, or vacate public road or alter a public road except to shorten it from end to end, Texas Transportation Code 251.051B. So it's got to be according to that, and I haven't seen language like that before where it needs to be unanimous, but in this case it does.
If you're terminating a road in its entirety, the Transportation Code requires it be a unanimous vote.
Okay.
These are, I'm not sure if any one of these is the entire road. Many of these are portions of these streets, but there may be one, I don't know if it's Lemon or whatever one that goes north and south, that may be the entirety of that one. Do you recall?
These particular roads all extend across the highway either to the north or to the east, so it would not be a total termination of any given road. So the unanimous consent provision would not apply in this case.
Also, there's been some disagreements about the road on the east side. I don't know if any of you are aware of that, but I kind of got in the middle of some of that, some phone calls between some of the owners of some property there. And I have been contacted by most of these people on this list, and I gave them the information on how to go about putting this together and bringing it to the court. These have been laid out, have never been established as roads, and I think it, and we had to do one for the strip center that's going in across the street a year or two ago, because there was a road that was platted right through the middle of the property that they bought there, and we had to vacate that for them to be able to build.
I remember the road and some alleys through that.
Well, I didn't understand why we were doing so many roads and wasn't really understanding the concept, you know, just.
The reason for that is because these people own acreage here, and many of those roads were within the same acreage, and their property is actually divided up by these roads in there, and they want to get it all in one section, from what I understand.
The two main property owners, Anthony Peskett and Dale Wakowiak, own the blocks of land in between these roads and alleys, as well as adjacent property. These roads and alleys have never been developed in the portion of the property that they're requesting it be vacated. So and we had them actually check with utility companies to make sure there weren't any underground lines, or overhead lines, or anything. So it's just, as the attorney said, many years ago, the town was laid out with somebody's idea of, you know, how it should be developed. And development has never occurred in that fashion throughout the town. We have done previous abandonments in Rones Prairie, and we've also had some, you know, tentative discussions with another property owner on the other side of Highway 90 about doing the same thing on that portion of the property, which is currently been, again, the roads have never been developed. It's currently being used as if it were private property. So it's just a case where, you know, the planners back when envisioned one thing, and the property owners saw, you know, a different way to go.
Could I add one more thing, is that there's also a general premise in the transportation code that if a road has been gated or fenced for 20 years or more, there's a presumption that it's been abandoned. It's not, again, it can be no adverse possession against the government, but there's a presumption that it's now been abandoned. And in the past, where the court has found a circumstance where a road has been under a fence or a gate for more than 20 years, the court has been inclined to go ahead and grant a vacation. I don't know that there are any gates or fences, and if there are, I don't know that there are gates or fences for every alley or road that we're talking about, but it seems to me the similar premise is to, if it's not been used for 20 years, has that established the fact that it's not necessary, that an abandonment has occurred? It's consistent, I think, with what Mr. Walker's saying, but again, I'm not being an advocate for doing this. If any of you feel a level of discomfort about it, I will tell you there was time that happened in the city of Rones Prairie as well that I felt like this happened before any of you, I think, were on the court, that action was taken to vacate a road, and later learned that if had additional information been obtained, that decision may not have been made. So I certainly leave it to you, but please don't rely solely upon my information. If you want to rely upon Mr. Walker, he's much more trustworthy than I am.
Do you know if the proposed high-speed rail goes through any of these properties?
I do not believe it does. It swings out, the alignment swings out to the west.
To the west of
in
that.
this area, because of where the.
Because this is all right in that southwest corner, right behind the weld shop and all.
Yes.
Yes.
Yeah.
And the parcel that Texas Central has purchased for the station is a little bit further west, and so the rail alignment swings over there.
But since we have an opposition to since this court has an opposition to the high-speed rail, I wouldn't want to give county properties away that would maybe enhance TCR's ability to run their business through our business.
Now, can you repeat?
I doubt it.
Just a brief, the reason why we were waiting on Stephen Wisnowski again?
They hired Mr. Wisnowski to survey this southwest corner of Rones Prairie. And so the survey you have attached that's at the back is what he did. He then helped, as I understand it, helped these landowners draft their application to provide to the court. At some point, when we received the information, we had concerns that maybe the entire width of a road was shown going to one landowner where we thought it should be divided and going between two landowners. I think Corey had that conversation either over the phone or via email, and we got that straight. I think he provided updated meets and bounds for all of the roads that you have attached to this order. I don't know that we're waiting on him at this point. There was a possibility he was going to be here on behalf of landowners today, only because he was made aware of today's hearing. He never said to me or to Corey that I know of that he planned to be here.
Do we know for sure that the meets and bounds are now correct?
To the degree that you trust me. I believe the order is correct. If you were to grant the vacation as requested, I believe the order would grant what they've requested and it would comply with the law.
I would also add that Corey has worked very closely with Mr. Wisnowski to go through all the different parcels and bits and pieces to make sure that's all correct and done properly, and I'm confident that it is correct.
You're a county employee and a citizen of this county. Do you think initiating this order is in the best interest of the county and the citizens of the county?
I do. Again, the layout of the town and this portion of the town has not been developed for many decades. And yet there are streets and things which are not on the public tax rolls. The wishes of the adjoining property owners are such that they would like to see the development of this go in a different direction, and I think it's in our interest to support that. We have no overriding interest and certainly no intention to go in and develop these roads for anyone. We're not in the business of developing roads, except in very rare cases. So I think it's in the county's best interest. It facilitates future development, future land use by the affected property owners, and it will put a number of acres of land back on the county tax rolls.
I'm not clear on, if I look at the drawing where you have the black lines, these are the properties that we're vacating. I still see additional alleys that may not be reflected in this. Maybe I'm looking at it wrong. I'm trying to understand your drawing. Penelope Street, 7th Avenue, none of these streets have ever been developed out.
No, ma'am.
But they've been divided into lots from the looks of it. If you have 4 or 5 1/4 block. But they're just big parcels of land,
Yeah,
right?
If you look closely on Penelope Street, you see up next to Highway 90, you can actually see the fencing for a gate there. That is fenced off.
Is that what that is?
That has been fenced off for many years.
Okay.
It's the main access to Mr. Peskett's property to the west. Again, I have been over the property. These portions of these streets have never been developed. There's no evidence that anybody else is using them. And if you look closely, the list of signatories on the petition reflects all the adjacent property owners. So everybody that is affected has been involved in this process.
So it's closing all alleys? Because this alley lines up with this alley, but I don't see it in this drawing, so I may be looking at it wrong. I'm trying to make sure I'm looking at it correctly.
It's a little hard to follow because there's so many bits and pieces, but the Mayfield Alley, all of that is being abandoned. All of Penelope Street west of Highway 90, all of Johnson Street west of 90, the alley between Penelope and Johnson, a portion of the alley between Johnson and Williamson Street, and then a portion of 7th Street, basically from Williamson Street down south of Penelope Street. So it's a little convoluted, but and then there's also a portion of the alley in block 23 that runs from Mayfield Alley to 7th Avenue.
Well, in block 36, is that a complete alley that's going away?
That complete alley is going away.
Okay. So, the alley goes on across to block 37, that's
Block 36 and block 37, all of those lots are currently owned by Mr. Paskett.
okay, those are going away.
That's all that's going away.
And then your comment also was everything east on 90 where the roads are indicated, those continue on.
Those continue on, they are, and that goes to the provision for unanimous consent. If it's a total abandonment of a road, these are only partial abandonments, so you would not require unanimous consent for this.
So these are partial.
Just partial. You can see on the layout, everything continues across 90, and everything continues across Highway 30.
Hey, Harry, would you hand this to Commissioner Walker? Corey likes colors, and so
Well, it helps to color. I color all day long.
that may be easier to look at.
A lot easier to follow.
Yeah, that was hard to see.
And I'll say, while you're looking at that, the issue we faced before that, after a decision was made to vacate, there was a concern later expressed by an adjoining landowner who said, wait a second, that was the only way of access to my property that you all vacated, and I was not aware of that circumstance. The law suggests that if you buy a piece of property that abuts a public road, you buy a private easement right, such that even if the Commissioner's Court vacates the public nature, you still have a private easement, right? So if there was someone who was outside of this area where you're cutting off a road, who used that road for their access, they would continue to have a private easement. But I would think that you would want to know that before you took that action. I think Mr. Walker has said every surrounding landowner is covered in this application.
See the color. Not that I know what your colors indicated, but.
Well, I think she wrote down letters that apply to the various meets and bounds that you
Okay.
have.
Based on all this discussion, it's worthy discussion, is there a motion?
Yes, I move that we approve the application of Anthony Paskett, Bill Wachovia, Sidney Wachovia, Bobby Moradi, Laura Paskett, Gary Moradi, Rodney Floyd, and James W. Klepper Jr. to vacate the following streets and alleys within the town of Owensboro, Texas. A portion of Mayfield Alley, a portion of 7th Avenue, a portion of Johnson Street, a portion of Penelope Street, and the 20-foot alleys located within the following blocks: 23, 34, 35, 36, and 37.
Second.
There's a motion before the court on agenda item number 17 by Commissioner Dobianski, seconded by Commissioner Mallett. Is there further discussion? Hearing none, all in favor say aye. Aye. Opposed? Motion carries. Thank you all on that. Okay, Commissioner Precinct 2, David Dobianski, agenda item number 18, discuss and take action on mass gathering permit for Grimes County.
Okay, on 8/31 of this year, we had a mass gathering out here east of town on 149 that there was a trail ride that left the facility out there and headed down 149, traveled down 222 to 2819, back down 1774, and then back up to the facility out on 149. And most of this happened after dark. And we had a meeting last week with the Sheriff's Department. DPS officer and Sergeant Wilson is here this morning. And I'm gonna ask her to come up, because she's gone out and she talked to the deputy. She went out there last Thursday after our meeting, I believe, and talk with some of the officers that were out there. If you'll come up and explain to us what happened, basically. Thank you.
Good morning, all.
Good morning.
No, I did not expect to be getting up and speaking. I just wanted to be here in reference to it, but I will, of course. I was made aware of it actually like Tuesday of the following week after the event had happened. And the sheriff had actually contacted me and stated they wanted to have a meeting in reference to all of it. And this is something that has happened. I do have 2 counties that I supervise troops in. And this has happened in Washington County. So when I came to the meeting and was told what had actually happened, I said, oh my goodness, this is the same, pretty much same event that had happened before. And Washington County had to go through a lot of meetings, drawing up, making sure the county, all the citizens within the county, and are aware of the fact there is a mass gathering permit that needs to be brought before the commissioner's court and get signed off on, so that everyone within the county, from fire to law enforcement, EMS, everyone will be aware of the fact that this event is going on. Emergency management in Washington County actually oversees and makes sure everything in compliance with the mass gathering permit is up to par before this event does take place in Washington County. Don't know how y'all will actually decide on who will be the one that will oversee it and bring it to Commissioner's Court for signage or what have you. But this trail ride, unfortunately, what they do is they get on the roads, and when they get on the roads, they don't take in consideration of rules of the road. And so they violate a lot of rules of the road. In the process, they have ATVs, go-karts, golf carts, and it creates a really bad taste in the mouth of your citizens that live on these roadways when they are trying to leave their home or get back to their home. This particular trail ride, with the mapping of where they actually went through and returned back to that field, was about 9 miles long. That is a long trail ride. And it was a lot of folks. And it did take all the resources of all the law enforcement, including the game wardens, to actually help facilitate it through. There was no way for them to be able to stop that many folks at the same time to cite or what have you. All they could do was take and actually help out with getting them through and allowing other folks to take and go where they are wanting to go, that live, the citizens, that is, that live within the area. In Washington County, what they ended up doing is coming up with what they have as a right-of-way permit as well as a mass gathering permit. I do believe the county attorney has received some of the documentation, so from there, I will let him take and speak on that part, because that's all the legality.
Sergeant Wilson, that was well done.
Thank you.
Well, I attended a meeting with Commissioner Dobianski and the sheriff and the sergeant this week, I guess this week or last week, I'm not sure. And the sheriff's office is very concerned about the impairment to safety that this creates. It's a use of lots of manpower. It's very difficult, if not impossible, to cite or arrest thousands of people or hundreds of people. Just don't have the ability to do that. And so once this thing once the law enforcement's made aware of it, they're in a pretty bad position to be able to deal with it. And you're just, at that point, just trying to have some management. And this issue has come up. I looked at my file. I've been asked by various commissioners back as early, I want to say, as '08 by a commissioner to read or have disseminated to him the mass gathering statute. Mass gathering statute exists. It is the law. It's a requirement that you obtain the permit. The court doesn't have to approve the law. It is the law. The question is, do you develop a permit? And as Sergeant Wilson indicated, Washington County faced this issue with a similar group or similar groups within the last year or two, and so they, I think, modified or drafted their application at that time for a mass gathering permit. But they also drafted an application or permit for a procession, or as indicated, a right-of-way permit and a right-of-way parade permit. So a couple of things that apply. Mass gathering is if you have 2,500 people. So lots of times that you never cross that threshold. But there is also a provision that if there be 500 people and there are minors out there, half of them are minors, you're going to have alcohol, then a mass gathering permit is required. As you can imagine, sometimes on the front end, folks won't necessarily know what that number is or whether or not a permit's applicable. The question is whether it's reasonably possible. That's really the question. What we'll have to face in this thing is how to deal with the enforcement, and you deal with the promoter. Anyone that's promoting this event can be arrested, can be charged with an offense if they fail to obtain the permit. That's going to be left to law enforcement to figure out how that enforcement is going to happen. But I will tell you from the meeting and even conversations before that, I know the sheriff is at his wit's end about their being feeling a sense of helplessness, inability to control these events, and putting landowners in a place, of course, where their access to their property is compromised, but also putting the safety of folks that are involved in trail ride at risk, and the folks that want to use these roads. I mean, we're talking about using the right of way, the causeway, the road itself, and the right of way, folks everywhere. And so it's something that needs to be managed from a perspective of safety, and this mass gathering permit will be an inroad in that effort, and it'll be up to the court to decide whether or not you want to approve what Washington County has done. I gave that to Judge Fouth this week, I want to say, and so I don't know there's been time for the rest of the court to obtain a copy of that. Obviously, I want you to read that and us to address the concerns that you have, if any, about whether it should be applicable in Grimes County. But there have been some events, even some at the fairgrounds, that have taken place that the sheriff the events have gotten out of control, and either they've not had security, or they've had security and security has not done their job, or security has disappeared and said, we can't control this thing, it's out of control. And there needs to be a way, I think, that the court attempts to address this. This permit process typically, or the statute provides that it goes through the county judge. The county judge is the one that decides whether to grant the permit or not. The one for the outdoor concert is for the entire court. That's not what's being requested at this moment, as far as I know. The court's not addressing that issue. All to say, I think where we are is, we left the meeting with the sheriff, and Commissioner Dobianski was tasked with putting this on the agenda so that we could start moving in the direction of doing something about it. I don't expect you to approve a permit in the dark. I want you to see what it involves. I certainly want you to be aware of the statute. I know some of you, if not all of you, have looked at the statute in the past. It's come time, though, I think, that we address it, and I think there was a real concern previously that you couldn't address trail rides with a mass gathering statute. I think what Washington County has done is innovative. I've not seen that before. I think it's valid. We can work through any concerns that you may have about it, but I think it's certainly worthy of your consideration, and we ought to start moving that direction. I don't know that you're ready at this point to approve a specific document, because I don't know that it's before anybody other than the county judge.
You said mass gathering is the law. What's the violation for violating that law, what is the penalty? I
I
mean,
believe it's for the promoter, it's up to 90 days in jail and up to a $200 fine, I want to say. It's a
Okay.
$100 or $200 fine.
so it's worthy enough to catch someone's attention. It's not like a Class C $100 fine or something.
I would think if it comes with jail time and a fine, that it would. Unfortunately, we're stuck with what the state law prescribes, and
Sure.
we'll just deal with it as we can. Although promoter is a pretty vague definition, anybody that promotes the event. So potentially, it's the handful of folks or the group of folks that are sending out these flyers or people that are using Facebook. Anybody that's promoting on social media, I think all of those people could be responsible. You even have the issue of, could the landowner be charged? Is the landowner a promoter? I think we've got to start at the head. You can't chase this thing, through 1,000 people. You got to
Right.
start with the folks that are putting this out there. But if you don't start, you'll never get there. And so that's the question. Do you begin to do something now?
Well, Commissioners, I have been provided copies of the mass gathering permit requirements out of Washington County and their road permitting data. And since I guess it would probably be a violation of the Open Meetings Act if I sent you copies of that via email, what I'd suggest is that my office work with the county attorney's office, put together documents for the court to look at. We'll get it back on the agenda in the very near future, schedules permitting.
We'll be happy to send it out. I think we were sending it to you if
Right.
it was going to be on the agenda and it needed to be an attachment.
Right.
I don't mind at all sending it to the.
If your office will, that will
Sure.
relieve me of that open meetings business.
Sure.
And, but in the meantime, the commissioners can look at it. In the meantime, your office and my office can work on trying to make it more applicable for Grimes County. And then we'd have that for review.
And as I said to you, and Sergeant Wilson raised the issue, I said to you in the other meeting that we had yesterday, there then becomes the question of, to whom do you give the obligation of obtaining the permit and then overseeing it? Because you would think that once the permit's filed, that person's now got to coordinate EMS, fire, and needs to go out to the site. So you're looking at a person that needs to do something. And we were facing the issue, I think, at the table with the sheriff, that the sheriff could take over, but then he's got multiple deputies and multiple folks that are then tasked with that. And it raises the issue of whether Washington County has it right. Should it be the emergency management coordinator that's handling that? And as you said to me, you thought that was certainly worthy of consideration. And
I did.
as we're doing this restructuring, that's just another task for that person. Not that I mean to throw duties on somebody else, but that it seems to me that's consistent with their charge already, is emergency management, managing things that involve putting together all of these players of fire protection, EMS, sheriff's office. And so that office may be the best to coordinate this. May not, I don't know that, but that's how Washington County has chosen to deal with it, and you may find that to be the best for Grimes County as well.
This discussion is probably a blunt awakening for our emergency management coordinator, and I was gonna break to him a little more gently, but now
Well, it's gonna
that
be an awakening for
he,
you.
now that he knows,
I did want to add something to the conversation. The Texas Association of County does provide their summary of mass gathering permits. And this is actually, Judge, you say the emergency management, but that's after you
right.
have overseen the permit and had a hearing and talked with the promoters and whoever's involved. But I hear you saying we're gonna be looking at two permits, a right-of-way and a,
They've labeled it right-of-way mass gathering permit, right-of-way permit, and right-of-way parade permit. I went through the documents and I didn't see three, I saw two, but they're saying the parade is
It's
separate
two.
from right-of-way.
I'm sorry,
That's
it's
all right.
only two. So the right-of-way permit also includes for parades, bike rides, like bicyclist events, as well as trail rides.
Okay.
So, depending on what the event is, and this is just how Washington County decided to do it. I'm not saying this is how it should happen in Grimes County, of course, but, sometimes depending on what the event is, amount of folks that will be attending or possibly attending per the promoter, both will actually be done. sometimes just one. It just depends on what type of event it is. So that's why you're only seeing just 2 permits.
Yeah.
So one permit
Right.
includes several things.
Could we get copies of that right away and watch, I mean, I pulled some that are off the internet for surrounding counties like Brazos, Burleson, Waller has one. But I didn't pull Washington counties. So sounds like they have something a little bit differently.
They do, and that's the thing I told the judge I would disseminate to you all. Yes,
Okay,
we
all
we
right.
have that, and Corey got that from their emergency services coordinator, and his email says, Washington County has a mass gathering permit, comma, a right-of-way permit, comma, and a right-of-way parade permit. I'm guessing that the last 2 are combined into one. I'm gonna give you what they provided to us. We need to make it ours, but they've dealt with this exact issue potentially with the same group or a similar group, and so
But this
they've been able to
issue
address
is
this.
gonna affect more than what you're seeing
You
as
bet.
far as
Oh, yes,
what
you
you're
bet.
talking about trail riding
Yeah,
group.
you
Because
bet.
you've gotta keep in mind now, you have what's the rodeo that you go to in Houston and the people come
Livestock
along?
rodeo.
Livestock rodeo, they leave the county. And is it, I know it's based upon the number, and most of the time, that's for the mass gathering. But I don't know what the right of way in that number
It's
looks like.
it's far fewer, the number's far fewer, and you're
Okay.
right, I mean, it's got to apply across the board, absolutely.
Yes, so, like I said, before you get there, I would like to have,
Sure.
see it, so if I need to have input, because I just wanna make sure that we're considering all that this is gonna encompass, parades, everything,
Frat
Uh,
parties.
yes.
that Come in and in Washington County, it encompasses everything. Like, in Chapel Hill has 2 separate events every year. One's Blue Bonnet Festival, they have to do the mass gathering.
Yes,
And then I think they also do the right-of-way permit because with the Blue Bonnet Festival, FM 1155, in a certain section of it, it's just closed off. There's no driving through because the booths and everything is all set up on that particular
this is
roadway.
in unincorporated areas, is that correct?
That's correct. This is just county business, so when Ren Fair is down in Todd Mission,
Right.
that's their issue, not
Right.
our issue,
Right.
sort of.
They also
She said
have
sorta.
the scarecrow. I'm sorry.
You said sorta.
Yes, because, like Navasota is part of Washington County. However, they have their, what's it called?
We're Grimes County.
Navasota Grind. But they have the Blues Festival.
Grimes County.
They have the Blues Festival and some of those.
Navasota is in Grimes County, I'm sorry. And, but
It's a
they have
municipality.
a musical event.
Right.
Well, that's within the city, so this will not affect
No.
anything that's within the city limits.
But you have groups like the Ferrari group coming through the county, so I didn't know how that affects those type of rides, but they come through and they stop and then they move on, but,
Correct.
we have to look at the big picture of what all it does affect and make sure that we're, not particularly picking on one
Exactly.
Correct.
entity, but all of them.
And that was an issue that when I was in the meetings and what have you in Washington County, that we took completely in consideration. So, they had another event that, it turned out to be a bike ride event, but it was on another FM road, but it was close to the county line of Washington County and Waller County, but it was more in Washington County. And so a mass gathering permit was done as well as the right-of-way because they were gonna be on the roadway as well. And it had the potential of being close to like 2,500, but they wasn't certain. They went on and they did the mass gathering, just in case, the promoter. So it just depends on what type of event it is. And if all the citizens within Grimes County is not aware of the fact that there is such a thing as the mass gathering permit, then that as well does put a damper on things. If they do not know, then they can't actually tell the promoter, hey, you gotta do this. This is a requirement within this county. And when I was speaking with the county judge, with the county attorney, the sheriff, and everyone at that meeting, I told them, I said that citizens around here are not aware that there is a mass gathering permit. And so I told them, you need to get this information out in all media ways possible, from whether you have Facebook, Twitter account, what have you, in a newspaper, on the radio, the local radio station, to announce it all out, so that all citizens within the county are aware of it. And that way, if they do decide to allow a promoter to use their land, and they of course get paid for their land to be utilized, that they are aware of the fact that this mass gathering permit needs to be done. If these individuals that's doing these events are planning to get on the roadway, also have that right-of-way permit or what have you put out. And that way, all of the agencies within, first responders, because that's basically what it really is, first responders are aware of the fact that this is going to be going on, and then we would have more of a heads up of what to watch for.
All right.
Appreciate your input, Sergeant Wilson. Thank you. So, John, your office will distribute to the commissioners what we've received. You and I'll work together on getting a blueprint for the commissioners' court to look at, and then we'll move forward on this.
Okay.
Thank you, sir. So on agenda item number 18, we'll take no further action at this time. If that's agreeable with the court.
Yes, sir.
Road and Bridge report. As soon as he's done. As soon as he's done, there, you take the floor.
Crews are continuing with our paving operations. To date, we finished about 5 miles of first course chip seal. We should be finishing another mile or so today. And then we'll lack just County Road 174, which that's gonna get done after the 1st of October for budget reasons. But the county crews will be doing right at 7 miles altogether when it's said and done. Our contractor Cornerstone has completed their work. They did 5 miles of double, 2-course chip seal, plus 2 miles of single course. I think in the past I've told you all, I've used that 5-mile number, but their total contract actually included 7 miles. We did Harrison and Bracewell with single course, and that was part of their contract, and brings their total up to 7 miles. Elsewhere, the Lake Road project is also complete. Our mowing contractor, Wayne Poole, has completed their second cycle for the year. So we're getting a lot of things wrapped up. If the weather cooperates these last few weeks of the year, we will complete all of the paving work that we had planned, with the exception of 174, as I mentioned. And we'll be working on that as the year ends and into October. Ditch crew's been busy. The mowing, we're continuing to do mowing ourselves when possible. Elsewhere, we now have the fully executed advanced funding agreements with TxDOT for our next round of bridge projects, which includes the 412, 215, and 201. Those will be bridges that will be either rehabilitated or replaced by TxDOT. And then we will have matching EMP projects to go along with that. And then we're also in the process of bidding everything and anything right now. We have all our annual contracts are out for bid. Those will be open next week. The sale of the property on FM 2445 will be open next week. Construction of the new maintenance barn is also coming up, and the construction of the 202 bridge replacement, which is part of the project under the GLO contract. Yes, sir.
On the 2445 property, have you been getting still a fair amount of interest and
We've
or?
had quite a few calls. We're still getting calls even this week. So I think there's a fair amount of interest in it.
So are people physically submitting closed or sealed bids for that, or how's that working?
I don't know if anything's been submitted yet. Those bids would go to Jessica's office. She's not here this morning. I know we have received bid packages on some of the other contracts already, even though they're not open until next week. I'm not sure about the sale of the property, that we've received anything on that yet.
So on the mowing and side booming, have, you said north and south, have we looked at Courtney?
The roads that are included in that contract have been completed.
They're completed?
He's complete with both cycles. He's done for the year.
Okay, so did they include Courtney? I don't know if I got an answer.
Yes.
Okay.
That is part of the cycle. Also, just for reference, our contract for next year for the mowing, we've expanded the number of roads we're including quite a bit. So we will have additional areas that will be under the mowing contract next year.
So when you say expanding, does it include roads like 316, 315? Have those roads been side boomed or mowed?
I couldn't recite the list of everything we've added. I can send it to you.
Which, please?
But we've made a substantial increase in the mileage of roads that we're going to have under contract next year.
I'd like to ask a question on the jail area in Anderson. Is that the property of the new
Yes.
law center, so that when the contractors are out, or the bidders are out there, they can walk
We
around?
started that last week, so it's not knee-high anymore.
No abandoned cars or refrigerators out there or anything?
No, no bodies, nothing like that.
Okay, thank you.
Thank you, Mr. Harris.
Thank you, sir. With that, with the court's permission, let's take a 7-minute recess. So much for the BB cog, huh? Annual meeting today, lunch and delay.
Yeah, the meeting was at 11, wasn't it?
Well, the lunch is at 11 and the meeting's at 12. You had to pay the $20 today for that?
I was thinking the meeting was at 11 and lunch.
Sure, can are you, I'm trying to turn it off. Are you positive? I punched something, a button.
I should at least start bringing my colored highlighters.
It is time for us to reconvene this court. I would ask you to please take your seats if you're going to stay. If you're not, we are now on agenda item number 19. I believe we're recording. Sheree, are we recording? Okay. Agenda item number 19, County Judge Joe Fouts, consider and take action to approve the Brazos Valley Area Agency on Aging, BVAAA, for FY 2019-20 vendor agreement for congregate and home delivered meals, and authorize the county judge's signatory. It's our attachment number 19. I've been through this agreement. I believe the county attorney has been through the agreement, but I did not verify that until just now.
Judge, it's the same. It's been executed for multiple years, and my understanding is that there's a change in the amount of reimbursement. From 19 to 20, the congregate goes from 648 to 654, so it increases by 6 cents, and then home delivered goes from 684 down to 654, a drop of 30 cents.
Now, just because the fuel prices are going down, et cetera.
Yeah, I don't know. I don't know.
That was the explanation I got. So with that, I'll make a motion that we approve agenda item number 19.
Second.
There's a motion before the court on agenda item number 19 by County Judge Joe Faust, seconded by Commissioner Walker. Is there any discussion? Hearing none, all in favor say aye.
Aye.
Opposed? Motion carries. Agenda item 20, review and approve proposed 2020 holiday schedule while relocating 8 hours available for Independence Day, which falls on Saturday in 2020. See attachment 20. I'm open for conversation on this, commissioners. I think the recommendation is the calendar that I have, Saturday, July the 4th, or the July the 4th, Independence Day is on a Saturday, and the idea of moving the holiday time to the Friday the 3rd, that makes it a 3-day weekend.
Sounds good to me.
Are there any other comments or observations or suggestions? All right, I will make the motion that on the holiday schedule for 2020, that the Independence Day, July the 4th, be recognized on Friday, July the 3rd. Or rather, that'll be the day we take off to recognize the 4th. I don't advocate changing the 4th of July, but I think you understand what I mean.
I second that motion.
I have a second, okay. There's a motion before the court by County Judge Joe Faust on agenda item number 20, seconded by Commissioner Dobianski. Is there further discussion on the holiday schedule for 2020? Hearing none, all in favor say aye. Aye. Opposed? That motion carries. Agenda item number 21. Discuss and take action to approve the fraud policy as an addendum to the personnel policy, attachment number 21. We've had this before us a couple of times, commissioners, and kind of massaged it a few times. Hopefully you've had a chance to go through it, because it is something that I guess it was the it was the tax assessor collector that initiated this, and feels like it's a good idea or an appropriate thing for us to have in the county. You'll notice on page 5 of 6 it has signatures for the Commissioners Court. Also on the back page it has signatures for all of our elected officials and many of our department heads, if not all of our department heads.
And I think last time we were just making some of the additions of the IT and environmental 911.
I believe that's correct, Commissioner. We've made all the wordsmithing changes to the language previously.
I move to approve the fraud policy as an addendum to the personnel policy.
Second.
There's a motion before the court on agenda item number 21 by Commissioner Mallett, seconded by Commissioner Dobianski. Is there further discussion? Hearing none, all in favor say aye.
Aye.
Opposed? Motion carries. Agenda item number 22, take action to approve Code of Conduct, see attachment number 22. This has also been before us in a couple of courts. We've had some discussion. We've had some wordsmithing and language changes. Comments? Questions, concerns?
Now, on the code of conduct that's signed by the employee?
Yes.
Okay.
Do we currently have code of conduct signed by our employees, or this is an activity you'll have to initiate?
Moving forward,
I'll forward it to them and have it each individual employee sign it and bring it back.
And that'll be a copy, a portion of their personnel file?
if there's no other questions, make the motion, we take action to approve the code of conduct policy.
Second.
There's a motion before the court on agenda item number 2 by Commissioner Walker. It's seconded by Commissioner by Commissioner Mallett. Is there further discussion? Hearing none, all in favor say aye.
Aye.
Opposed? That motion carries. Agenda item number 23, discuss and review district judge's compensation order for county auditor and assistants according to local government code 152.031 B, little b. See attachment number 23. You have the order in front of you with the designated increases for the county auditor and the auditor's staff. Those numbers are currently in the budget, correct? Okay. And this is ordered by Judge Kramer out of the 12th and Judge McKay out of the 506.
I make the motion, we're just reviewing. We don't have to make a motion, right? We're just
So
reviewing.
just discuss and review. I mean, it's already in the budget and I believe they have authority over us, so this is for your awareness.
Okay, thank you.
All right. We will now go to agenda item number 24, consider and take action to approve the contract for county funding for Emergency Medical First Responders, Inc., and authorize the county judge's signatory, attachment number 24. The paperwork that I have in front of me, it has an effective date of October 1, 2018.
We'll be
believe.
changing the dates.
Ma'am?
I said we'll change the
Yeah,
dates.
so it just needs to be changed to October 1, 2019. And then on the term, it goes October 1, 2019 to September 30, 2020 would be the change.
And the payment by the county is the same.
Correct. Or proposed to be the same, and that's what's been submitted to the budget.
If there are no further questions, I'd like to make the motion, we approve the contract for county funding for Emergency Medical First Responders Incorporated and authorize the county judge's signature.
Second.
There's a motion before the court on agenda item number 23 by Commissioner Walker, seconded by Commissioner Dobianski. Is there further discussion? Hearing none, all in favor say aye. Aye. Opposed? That motion carries. Agenda item number 24, consider and take action to approve the contract for county funding for 25, receive and take action to approve the MOU, Memo of Understanding between the BV-COG Transportation Partnership Program and Grimes County, are attachment number 25. And again, I think this is pretty much similar to what we've done in the past.
Same numbers, right, Jesse?
I move to approve the memorandum of understanding between BV-COG Transportation Partnership and Grimes County.
Second.
There's a motion before the court on agenda item number 25 by Commissioner Mallett, seconded by Commissioner Walker. Is there further discussion? Hearing none, all in favor say aye. Aye. Opposed? Motion carries. Agenda item number 26, consider the proposed budget FY 2019-2020 and take action to adopt the budget with a record vote pursuant to local government code 111.008. Note, budget must be adopted before tax rate pursuant to local government code 111.010.
Mr. Fultz, I have a question for you.
Yes, ma'am.
We typically have that right behind the adoption of the budget. We'll be doing that later as far as adopting the rate. Is that correct?
Now, I'm hearing that that's the plan. I don't know if there's any issue about it being a different meeting, but if that's the question for me. My understanding is it's the 25th.
It's the 25th.
Yeah, it doesn't really matter, they could both be on the same one, but we have to make sure we do this first, so. There's some weird, I think there's statutes regarding about when we're supposed to adopt the tax rate too, so. I think that has to happen on the 25th, I'm not mistaken. I don't have my calendar with me.
It is the 25th.
So you're saying that there was a timeline?
Now, of course, if the rate has got to be adopted before the end of the month, but I think it has to be adopted on the 25th because I think it had to do with the time between the last public hearing, which was today. Is there so many days between them? I don't have the statute in front of me. I can't recall.
I just wondered why it wasn't on here.
Because I wasn't real sure.
Okay, no problem, no problem.
Yeah.
We're working on the budget. I had a question in terms of, trying to find my little thing, but how is it going, how do we, right now we have run costs in for the fire departments. Can we speak a little bit about that?
We can.
Okay. I don't know where y'all are in the, because we're not going to do run costs. Am I hearing correctly?
It is my desire that we do not do run cost or hour payments to the VFDs for this upcoming budget year. The monies are currently in the budget, but it's my plan to not offer those to the counties. We've made some changes, we've made changes to the contracts for the VFDs. None of those have been signed other than the interlocal agreement that we approved today for Navasota City Fire Department. And I'm meeting with 3 departments tomorrow to see what they have on their agenda or what their desire is to have in the contracts. I've met with the county attorney. I've met with one of the county auditors. And we have prepared our proposed language for the VFDs, and that's being taken care of in the county attorney's office. Well, not as we speak, because he's got his worker bee behind him, but it may already be done. Anyway, that's what I'm going to be presenting to the VFDs.
So what I thought I heard come out of the last meeting was a stipend and certificate pay or a certificate?
The certificate pay would only be offered to the volunteer fire departments that could show that they are certified for extrication. And again, this is just Joe Faust's thought. My thought was that we would offer a $2,500 a year stipend for that certification. If a department has it, they can present the documentation that shows that they're appropriately trained and certified to do that, then we would give them an additional $2,500 along with the $32,500, which would take them up to $35,000 a year. I'm also going to be proposing in the language that we don't pay the $32,500 all at one time. We would do quarterly payments at the beginning of each quarter. And that would be paid only providing that they can meet the agreement, meet the requirements that they must live up to within that contract, i.e. they've got to show that they're for not-for-profit, which in most instances a 501(c)(3) or 501(c)(4). One of those or both of those. I know the 501(c)(3) is a nonprofit. So they need to meet those qualifications. They're also going to need to be able to make sure that they're current or in the process of getting their organization in line with the Internal Revenue Service and those particular filings. So that's
train?
That's my plan of approach, well, that they have to have whatever the state says that they need to have for trained personnel. It's not just a matter of, oh, hey, come on out and fight fires with us. They're gonna have to have their particular training documentation. And it's really no different than what they've been working under previously.
But all of this is to incentivize, I guess, people to work toward,
All of this is designed so that they follow the rules, that the county follows the laws and the codes that we're obligated to follow in providing funds to these fire departments.
Now, are we looking at basic certifications of a department, or are we looking at only one certification?
That was a question mark that I had. What are the particular certifications? And I don't have that information in hand at this moment.
Okay, because when I asked for information from some of the departments as far as certifications, I got individual certifications and I got department certifications. So are we working with department certification? Because there could be a lot of certifications
Well,
individually.
understand, and I personally feel I'll have a better understanding when I talk to the three departments tomorrow, because they're closer to it than I am, and more knowledgeable, so I hope to gain from that meeting with them, and that's at 2 o'clock. If one of you would like to join me at that meeting, you're welcome to do so, but.
Well, I guess my question is to the auditor then, is there an issue with the lines remaining the same in this current budget, or do it need to change? Or the name of the line change, or?
I don't think it would look good to publish the budget as approved and having the money in the run cost line item, and then having to go back and do a budget amendment and take that money out. Because then it looks like you're really taking money away from the fire departments. I think what could be done is put an additional $2,500 per fire department in the
Extrication line,
extrication line, and
if they meet it.
Are
we
you
pay it.
calling it extrication line, or would it be certification? Because he doesn't know yet what the certifications are gonna be.
I would say certification line or certificate.
So rather than just 2,500, move a set amount to the certification line and do away with the run cost line? Is that what you're saying?
Well,
I don't-
until
I
we
don't know.
actually get together and really discuss the contract with the fire departments, I mean, if they've been used to running on $50,000 and they legitimately have that expense, and we limit them to $35,000, we're really hindering our fire departments.
And that's why I was asking,
So
how
I
many
think there needs to
certifications are
be
we
some
gonna
money
look
in there.
at?
Yeah, some money probably needs to be in there to keep that flexibility and actually, and find out from each fire department where we're really at.
Yeah,
And
because
that'll
I
be
wouldn't
for
want to
each
tie our
contract.
hands to just one certification. Because some of them have additional certifications like water rescue, or, you know.
Well, it could be based on what type of equipment they have as well.
Yes.
To keep
So
that-
I just wanted to make sure we're doing our house cleaning before we approve the budget, and we have run costs in there, and it's not run costs, it's something else. I just thought I'd throw that out there.
Unless we just put it, all of it into one sum, and then we spend it all, but if we don't, we don't. But we kind of, we're at a time crunch right now before we actually meet with the fire departments individually.
Mhm.
So, I mean, that money can be in one line item, and then we can come back later and
I'm just trying
change
to,
the
you know,
amount or
for the
something
sake
as a
of,
budget. But not
of a
call it a
citizen
run, not
looking
call
at
it a
the
run, yeah, not call it a run, put it in the
certification,
stipend.
You
certification.
wouldn't want to leave $200,000 in the stipend line, would you?
If we, I mean, I don't want to not have enough in there too, if we're not just going to give more, if we're not just going to give $32,000. I mean, a
Well-
lot of them have, 32, and then what's the average run, $10,000?
Well,
It
So-
varies.
the departments, if you divide it by the 8
That's the average.
departments, it runs about, the expenditures, I think 52 to 55,000 a year per department.
So if we just strict them 35,000, we're cutting out $20,000 out of their budget. So, I mean, that might be a good thing, might not be a good thing. So that's kind of where, I don't think we should, if we don't want to call it run money, we just take it out and put it into the stipend itself.
That's what I
Until
was
we
thinking.
actually have what,
The stipend is going to be.
yeah, what the stipend's going to be. And it may vary between fire departments, so we don't know.
Well, I'm certainly open to suggestions.
I mean, unless we can get with the fire department between now and then, I mean, as far as approve the budget before the 25th.
This is the
That's gonna be a hard
25th or
ask.
27th, what date is that?
25th.
I believe we're scheduled on, if Wednesday is the 25th, I think that's where it's on the agenda for us to have a final approval of the budget.
That's gonna be a difficult ask at this point in time to do
They
that.
give us 2 weeks.
Okay, with that being said, I know there was another issue you want to talk about, Ms. Mary, as far as,
On the new building, if we move forward with that, I put up there before the court started, the sample amortization that I pulled off the internet yesterday. I know this is taking a 3.5% interest rate. And, we would have to make a payment in March of 2020 and in September of 2020. And so those two payments equal out to $873,590.25. So that's money that we need to budget in debt services for that loan.
if
And
we
that money
move
would have
forward
to
with the
come-
5 million, that's the 5
If we
million.
did- Right. And that would be money that would have to come from ad valorem taxes. So that would basically mean we might need to cut the budget by that amount.
Well, that's if we did 5 million. That's not necessarily what that number's gonna be,
Aren't we gonna have, don't we have a meeting scheduled tomorrow?
We have a workshop, yes, sir.
which would take this into consideration.
So that hopefully we can, Commissioner Cox, we'd have a better handle on how much we probably need.
But it's not in this particular budget, and
But it would be in 2020 when we're not collecting any taxes on that, we'd have to make those payments?
Your taxes won't be collected for the debt, the INS will not be in until 2021.
Okay, so but we have to start paying in 2020. Okay.
and so that was one of the things we had not considered when we proposed this budget. So since
So I guess
the
we could do that.
workshop is until tomorrow,
Well, we can move the budget to the 25th before we approve the tax rate.
We can?
Okay.
Is that the consensus?
I would love to get it behind us, but that is where we are at. I mean, we still have some questions up in the air.
All right, so we're gonna take agenda item number 26 and move it to the 9:25-19 agenda. Agenda item number 27, consider and take action regarding the bird ban and authorize the county judge's signature. We have had scattered rain, but I would consider taking no action.
How much time do we still have on it?
We have, I did a count, we put it in place on the, I believe, the 14th of August. It's normally in place for 90 days unless you lift it sooner, so that's that would coincide with the first meeting in November.
So no action on number 27. Agenda item number 28, receive any updates on the strategic plan. Is there anything to be offered? Hearing none, okay. Agenda item number 29, to discuss and take action to approve possible purchase for real property exchange. It is expected that the court will convene a closed or executive session regarding this item as authorized by Section 551.072 of the Texas Government Code. Deliberation regarding real property, see attachment number 29. Mr. Foltz, do you see any reason for us to go into executive? Is it
I don't,
more appropriate or less appropriate?
the issue with the executive session is typically to avoid a circumstance where you disclose information on real property that compromises the county's position. I don't know that that's possible in this case.
I agree.
mean, there's not but one person that this could be done with. And so it's an attachment already, and so in all honesty, it's subject to request.
Sure. With that, thank you, sir. With that, we'll move forward. You have a picture on the back of your attachment. But again, in summary, what this is, one of our citizens, Jim Westmoreland, has property that butts up to the county's property where the new business justice center is. And Mr. Westmoreland also has a piece of property that butts up to the east side of our property but extends out to Highway 90. Mr. Westmoreland and I have talked about, let's do a land swap if he would give us an access going from our county property, you can see the little yellow dot on there, and then where the shaded area goes out to 90 toward the top of your page or to the right of your page, that's Highway 90. So the idea is Mr. Westmoreland will trade us that strip of property, which would give us a road access out to Highway 90. In exchange for that strip of property, come back to where the jail and the sheriff's office is. If you would go towards the top of the page, but you'll see another shaded area. And it would be proposed that we give Mr. Westmoreland that much of our property in exchange for the previous property I talked to you about just a moment ago.
What
And
is
the
this
reason
one?
for, I'm sorry?
I'm sorry, I was wondering, what is this? So I know where I
Those are
am.
just some of those buildings that are at the back of the sheriff's office. They've got a, I don't know,
So that's not
Deputy
90,
Cook, that,
one-
back there by the shooting range, that building
Oh,
off to the
okay.
left.
All right, I know where I am now.
That's Hogan's Alley, that's for training.
Yes.
This is to the north of the property.
Yes.
Okay.
So the idea in talking with Jim is, hey, we have this property, we'll swap you this property for that property. That would give us a potential of putting an additional access from the new Justice Center out to Highway 90 instead of only accesses being out on 149 to fight with all the school traffic and everything else.
And this is an exchange of property?
Yes, yes, ma'am. And I've had our county attorney involved in it, and I'm going to take it that all of his dimensions and all of that are true and correct because he's far more of an expert at that than I.
Well, let me make a comment, I guess, a couple of things. Under the local government code section that you have on the front page of the handout, there's a requirement for a notice in the paper that the court will accept exchanges of real property. I doubt very seriously anybody else has the same property to offer or similar property to offer, so it's a formality, but it's there. You see that in subsection B, and then subsection C talks about an appraisal. Question becomes, do you use the appraisal district's valuation? That's what I used at the top. The judge asked, or I talked with the judge and Mr. Westmoreland, and it was Mr. Westmoreland's proposal that we do a swap using the appraisal district valuation to get to the amount of acres that would be given to him. So his tract is valued at a higher amount, so you see that in the exchange he gets more acreage. That's all a proposal to you in this drawing. Corey did this drawing using the appraisal district map. It's not, I guarantee you it's off by some minimal amount because you're just using a cursor and doing the best you can. So we also have the issue of having these two-track surveyed. Certainly you don't want to have them surveyed until you know what acreage you're going to exchange. We wouldn't want to tell a surveyor to go out and do this and then have to pay him to do additional work. But all those issues remain, the publication, the appraisal, the survey issue.
And just as a side note, I have contacted TxDOT and shared with them what we were proposing to do to make sure that line of sight and everything is okay, because you got that 149 that comes into 90 already, and then it makes the jog there by the Anderson School property and then jogs over to the 149 going up to the school. And I have a commitment from TxDOT that there is not a there's not a vision issue if indeed we were to have access to 90 and we were able to acquire that piece of property from Mr. Westmoreland. And whether we put that roadway through now or later, it does give us that option to have another entrance exit to that facility. So that's for your consideration, Court.
So this is basically an exchange. There's no partial payment.
That's correct. And because they're not of equal value, that's why the tracks are a different size.
It's dirt for dirt.
And it has to run 3 consecutive weeks.
You see what subsection B says. That's the requirement of the local government. 3 consecutive weeks before the date of the exchange, date of first publication being before the 20th day before the date of the exchange.
Sounds like an attorney wrote that.
Yeah.
I believe we need to postpone this, table it. There's several things going on right now. The publication being one of them. That we might need to consider this at a future date.
Are we required to have any public hearing on this?
No, you
Just
see all of
notice.
it. You see it. The public hearing will be when you consider it in court. I mean, you're not granting the exchange today. You're doing a publication to say, hey, we'll take anybody that wants to try to exchange with us, and you're putting out what piece you're going to exchange. You wait to see if anybody makes any offer. The only one that I expect to make an offer is Mr. Westmoreland. Then you will come back and approve that exchange, assuming that you're going to address the survey issue and the appraisal issue, which we've done before, accepting the appraisal district valuation. We're talking about a minimal amount of acreage. The question is, how much in way of cost do you want to put into this exchange? And the appraisal is not going to be cheap, and certainly the survey is not going to be cheap. So there are costs that are relevant and should be considered in this exchange. If you were to start the process, or say, let's start the process, keep in mind you have the publication cost. I mean, that's not free either.
So we have the publication costs, and would we use the appraisal district's value, since this is 1.5 acres we're talking about?
It's entirely up to you.
So we don't have to have an appraisal.
The statute says appraisal. It's up to your interpretation as to whether you believe that you can use the appraisal that's been done by the appraisers at the appraisal district, or whether you need to employ an appraiser specifically for this purpose.
Which we've done.
We've done
several times.
We've done it both ways, correct.
So
if it was a large tract, I would say, heck yeah. I mean, we need to have an appraisal. It needs to be done. It was done for the new location on 2445. But when you're dealing in a tract that's an acre or two, and you're talking about the benefit to the citizens and the fact that you have already a valuation that nobody has potentially objected to previously, can you justify using that amount, knowing that the cost of getting the appraiser will leave the taxpayer in a worse position because of the cost of it? If it were a significant tract, then I would say there's no question you need a separate appraisal. But
So-
We're dealing with small, very small tracks here.
On your property ID numbers, that's the total amount that's there currently at those two properties. But the exchange amount is the 1.5 and 2.343 to Mr. Westmore.
That's correct.
What we're considering today is whether or not we pursue the exchange.
I think that's correct.
I guess I want to hear your concerns again, why we would not really consider pursuing the exchange.
Well, there's several, as noted by the county attorney, that need to be taken care of probably before we take any action on this, just to make sure everything is in order. We don't need it. We already own land on 149 to access any potential building out there. We haven't even decided if we're going to build a building. So what would be the point in doing this exchange or voting on this today without already first have made the decision to build the building? We're out for bids on that right now, but there's no guarantee when those bids come back that we're going to pursue that. And while I'm certainly not challenging what the judge said, I'd like to see something in writing from TxDOT that says there's not a safety concern out there, because I drove it this morning and I would argue that there is. That being said, I've heard that there may be a turn lane installed there. I'd also like to see that in writing. If that's the case, then I would think it would be prudent upon us to get TxDOT to put it in writing on what they propose to do. It's a safety concern. I know backing up traffic on 149 inconveniences people getting to school, and I understand that and appreciate that. But I have a safety concern as well, backing up traffic on Highway 90 with people doing 70 miles an hour coming into town on a hill. I just think there's too many other elements to consider. I'm not saying can't do it in the future, but I'd like to have the opportunity to discuss that with the court. We've got a meeting tomorrow even.
The speed limit in that area is not 70 miles an hour right there. It drops down to 60, I believe.
Well, the speed limit in Anderson is 35, and they can't enforce that.
How long is the driveway we currently own? I mean, how far? I mean, there's a lot of, if I can recall the property, it kind of goes downhill, then it comes back up to 149, right? And that's a pretty good length. It's 200, I thought I saw 200 and something.
Oh,
Meaning
the
feet.
numbers that, for the preliminary,
For the driveway that we looked at, that was in the bid packet. We looked at,
I think they put 225,000.
oh, that was the number, 225,000, but I'm saying the length of the road.
For the driveway.
Okay.
Going out to 149,
I just
don't recall that one.
wondered what the length in comparison to this.
It's shorter.
This is shorter?
Yep, keep in mind though, if that facility is built out there and you have school going on, you're gonna have an issue with people being able to get to work there in the morning. And you're gonna have a lot of traffic there in the afternoon. Having this other option of putting a road out here is gonna be a tremendous value to not only to the facility, but also to the sheriff's department. If there's a lot of traffic out there and they have an emergency, need to get some deputies out on the road from the jail, there's another option rather than going down 149. Because in the mornings, the traffic is backed up out there, if you ever been out there early in the morning.
Now, I thought we addressed what concerns you had. What were the other concerns that he said that, as far as the appraised value, and what was the other one?
Survey, publication.
So do we have to have it surveyed prior?
You don't have to have it surveyed prior, but I would think that you'd want to start with, to get to the amount that you're willing to exchange, you have to know what the exchange rate is with Mr. Westmoreland. So I don't know how, it's a chicken and the egg problem. Do we survey the piece of ours that we want to exchange, or do we just say how much we think we would end up exchanging with Mr. Westmoreland, given the exchange rate, the appraisal district gives us that number? So I don't know that you have to have the survey on the front end, but you're not gonna have the specific acreage that we're willing to exchange until you survey both pieces, I would think. I don't know, I hadn't thought that through, because what you're doing is you're putting out there what you're willing to exchange, right? And then you're taking folks who are willing to offer you something in exchange for that. Well, to identify the amount of acreage that you're willing to exchange, in this particular scenario, it depends upon how much, how big the acreage is of Mr. Westmoreland to dictate what that acreage of the county is. So I can think that, we can think that through and decide whether or not the survey absolutely has to be done, or we could use the numbers that we've already used off the appraisal district. My fear is that you're just gonna be left with 2.3 more or less. You're gonna be rounding or allowing folks to, or putting a disclaimer on your publication that says you're not certain of the exact acreage. That's not all that big a deal. At the end of the day though, before you do the exchange, I wouldn't feel comfortable doing a deed that says we're exchanging this property without surveys of both pieces. So does that have to be done today? Technically, no. Publication certainly has to be done. The appraisal, the issue of whether to get an appraisal has to be addressed, or should be addressed.
I was always taught to get a survey to know where your land is in the state of Texas. So I have no objection to the survey. I just wanted to know at what point it had to be, I think that the publication or the general circulation is making citizens aware that the county is thinking about exchanging property.
I'm sorry, say it again, I missed that.
Is the publication is to make the citizens aware that we're thinking about exchanging property? Or is it the actual exchange?
Before the Commissioners Court exchanges an interest in real property, notice that the county will consider offers for an exchange of the interest must be published in English in a newspaper of general circulation.
So this is just a notice that we were
That the county
considering.
will consider offers. It's offers plural. And Mr. Westmoreland would be one of the offers. I doubt there will be any other offers.
And this is a shorter driveway.
I've heard folks say that, I don't know that.
It would be longer to go from the Justice Center to Highway 90 than from the Justice Center to 149.
Okay, it's longer. Okay, okay. So it had a
It's really
length.
just a connection to the parking lots.
Yes.
Yeah.
It's just a connection really to the property?
To the parking lots.
It goes all the way over to the parking lot? I mean,
Yes. This, eventually, what would happen is this road here would hook into the parking lot of the property, giving access to come to the back of the property, to the side of the property, to the front of the property, or back out to 149.
and this says it's 80 feet.
Width.
That's width? Okay.
The width is 80
Okay, so the
foot.
1,000, I can barely see it, 1,039 is the linear feet. Okay, I didn't see it. So I'm through beating the horse.
Two-way lane? Is that right in that, for a two-way lane?
It's 80, I was looking at the width, it's 80 wide.
Right.
We have 60-foot right-of-ways, so, or not even those, some places. Yeah.
All those trees that Al did on.
This exchange is, it's an exchange. I like the fact that it's an exchange. There's value, but no payment of cash.
Correct. Yes. And this just makes one of Westmoreland's properties a little bit bigger, and one of his properties a little bit smaller, but we'll take off of that smaller piece and use it to our advantage for an additional access at some point if we desire.
What was the thought process, Mary, when the county bought the piece of property out on 149?
Well, I have no idea.
Has
That's
been-
long before my.
Yes.
There's a piece of property there that I believe was intended for access to a potential facility out there.
He's talking about the purchase we made from Mr. Capps, if I made no mistake.
There is, on his east side of his property, there's,
Because I've been advised that that was the intent of the purchase of that property.
to access 149 for the new center.
Mhm.
And I think that's the case, isn't, yeah, because you already have the sheriff's entrance on there, Commissioner, and then putting another one, so now that gives you two on 149, but that doesn't, my idea was it doesn't relieve your congestion on 149. By having this exchange of property over to 190, that gives you another avenue for moving traffic. in and out.
Options. We're not one way in and one way out.
Right. Well, and part of the reasons for having that other piece of property, I believe that the jail entrance to the sheriff's office, that if, and I'm only quoting hearsay, but if they had a lockdown at the jail, that effectively shuts down the only in and out access to that new facility. Does that make sense? The current access that we have into there.
The current one.
If they had a jail crisis and they had a lockdown, then I'm told that that road gets shut down until the lockdown is released or removed. And if you had people working in those offices or citizens in those offices or juries in those offices, they wouldn't be allowed, they wouldn't have access to get out until the lockdown's removed. By having the other entrance that comes out on 149, that gives it, the building, its own in and out. The idea that I worked up with Jim Westmoreland, we have another access that would go to 90, that put you on another main road. Commissioner, I can get the information in writing on the, not a issue with division, I can get that from TxDOT. And if that's, if we need that and more time, then, but I guess we shouldn't, we won't run any ads or anything like that or notices because we don't have an agreement on the court. This is what we want to do. Is that correct?
You have to put it to a vote, if that's what you're saying.
Well, is there a motion? There's no vote to be made unless there's a motion.
I move that we approve the possible exchange and move forward with the process.
I'll second it.
There's a motion before the court on agenda item number 29 by Commissioner Dobianski, seconded by Commissioner Mallett. Is there further discussion?
I've just got a comment. We're having a meeting tomorrow to discuss the whole very building situation. I don't know what the rush is.
Well, I don't think this is necessarily for the building itself. When we don't build the building, it'd be nice to have another access on Highway 90, I think, just for the value of the property itself.
And I thought what I heard say we're considering, not that we've made a decision, but we're considering an exchange. And if there's any blowback from a public member, or somebody wants to come forward, or somebody wants to purchase it, or somebody else, has an interest in the county land, then they have an opportunity to come before we make a decision. I thought that's what I heard, I understood.
Is that correct?
If your motion is, by moving forward, is to start the publication, then I'd say yes, but I assume that's what you meant, to start the publication.
Yes.
Is there any further discussion? All in favor, say aye. Aye. Opposed?
Nay?
Motion carries. That brings us to agenda item number 30. Is there a motion to adjourn?
I move we adjourn.
Second.
Discussion?
Might get to the last.
All in favor of adjourn, say aye. Aye. Opposed? Motion carries.